Mic check. Mic check. 1, 2, 3, 4. PLDRC meeting March 20th, 2025.
March 20th, 2025 hearing for the Planning and Land Development Regulation Commission is now called to order. And if I could please have everyone silence any audible devices that you may have. And if you would please join me for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Good morning, everyone. I would like to thank you for being here this morning. And Ms. Summers, could I have the roll call?
Good morning. Ms. Craig? Here. Mr. Sixma?
Here.
Ms. Shelley? Here. Mr. Costa?
Here.
Mr. Mills?
Here.
Thank you.
Okay, well, thank you, Ms. Summers. We do not have any minutes this morning, so if anyone would like to speak for or against any of the cases being heard today, there are some forms at the back of the dais here that you'd fill out and give to Ms. Summers to my immediate left. And we will be limiting you to a 3-minute time limit. After the comments have been heard, I will give the applicant an opportunity to address any concerns the speakers have and answer any questions the commissioners may have. And at this time, I'd like to turn it over to Mr. Soria for legal comments.
Thank you, Mr. Chair. This is for the applicants and members of the public that decisions by this body on special exception cases and cases which rezone real property from one classification to another pursuant to the zoning ordinance are recommendations only to the County Council and do not constitute a final hearing. New evidence may be introduced at the County Council public hearing. Decisions on variances made by this body constitute final action subject to an appeal to the County Council. And what this means is that no new evidence may be presented at the time of the County Council public hearing on the appeal. An aggrieved party that appeals such a decision is confined to the record made before this body. Hearings by this body on rezonings, special exceptions, and variances are quasi-judicial in nature, meaning that this body is acting more like a court and must take into account all oral, written, or demonstrative evidence presented. Their decisions on these cases must be based on competent substantial evidence in the record, and competent substantial evidence has been defined as that evidence a reasonable mind would accept to support a conclusion. Thank you, Mr. Chair.
Thank you, Mr. Soria. While on legal comments, I would like to ask the Commission to disclose for the record any ex parte communications that have occurred before, during the public hearing at which a vote is to be taken on any quasi-judicial matter. And I'll start to my immediate right with Ms. Craig.
I have none.
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 I had one on case number S25001 and V25023. I did have a discussion with Mr. Lewis. Okay, we do have an item to be continued or withdrawn. We're not sure yet, so we're going to make it as a continuance right now. And
we just got an email from the applicant. They've asked to withdraw PUD 25002.
all right. Okay, we don't need a motion on that. They're just withdrawing it, correct? So if anyone's here for that case today, PUD 25002, that item has been withdrawn. We do have some old unfinished business, so Ms. Shelley, could I get you to read that into the record, please?
Yes, sir. Case number V-25-010, application of Alana Smith, Cobb Cole attorney for Frank and Maria O'Connor, owners, requesting variances to the accessory dwelling unit ADU regulations on urban single-family residential R4 zoned property.
Ms. Ray, this one's yours.
Good morning. The applicant is requesting 2 variances for an existing accessory dwelling unit to resolve a code violation. Variance 1 is to allow the ADU to be located in front of the rearmost point of the detached single-family residence. Variance 2 is to allow the ADU to be greater than 50% of the living area of the principal structure. The property is a through lot, so it is subject to 2 front yards and 2 side yards. The property is currently developed with a 960 square foot single-family residence that was constructed in 1985 and a 590 square foot detached garage that was constructed in 1987. The detached garage was later converted into the accessory dwelling unit. A code complaint was received in November of 2023, and upon review, it was discovered that the ADU does not meet the regulations. The single-family residence entrance faces the southern boundary line, causing the location of the ADU to be parallel to the single-family residence instead of behind it. The variance requests are not likely to be injurious to the area because the ADU is located within the structure that has been in place for approximately 38 years. Staff's recommendation is approval of variances 1 and 2, as the requests have met at least 3 out of the 5 criteria. I'm available for questions.
Thank you, Ms. Ray. Any questions for staff? Is our request to speak speaker working properly today?
Yes, sir, it's working.
Got it. Okay. All right, we will be using that cue. Okay. Is the applicant present? Good morning. Could I get your name and address for the record, please?
Alana Smith with Cobb Cole Law Firm, 231 North Woodland, and I don't have the remote, I believe.
Okay. You'd have comments you'd like to add to this case?
Excuse
You
me,
have
sir.
comments you'd like to add to this case?
Yeah, I'm going to do a brief overview of the request.
Okay.
Am I pointing it in the wrong direction, or? Excuse me?
There we go.
It went a little bit. Here, sir. Okay, wait, you're pressing this button. Right there. Okay, I tried all of them, but. Okay, thank you. Okay, so the first variance to allow the ADU to remain in its current location. So the code requires ADUs on lots less than 1 acre in size to be located so that its front facade is rearward of the rearmost point of the principal detached single-family dwelling unit. So what that really means is the ADU has to be behind the rearmost point of the principal dwelling. And on through lots, this means the ADU must be located behind the rearmost point of the principal structure as measured from either right-of-way. So as measured from Ace Park Drive to the west or Sunset Ave to the east. And then the dual frontage lot prevents the ADU from being able to be located behind the principal structure because the rearmost point from one right-of-way is the front yard from the other right-of-way. And the existing ADU is situated parallel to the principal structure instead of behind it, just to match the orientation. So the second variance to allow, I don't know why that says proposed ADU, sorry, that's a typo, the existing ADU to be greater than 50% of the principal structure. So under the code, ADUs cannot exceed 50% of the living area of the principal structure, but this excludes spaces such as garages and porches and other spaces from the definition of living area. So the existing ADU is 545 square feet living area, and that's a total of 590 square feet, and then we subtracted the 45 square feet of storage space. And the principal structure is 960 square feet, so the ADU can only be a maximum of 480 square feet, sorry. And then, so it currently exceeds the maximum permitted size by 65 square feet. And then here's a footprint, so you can kind of see the orientation, how it's laid out, and both structures are facing the south boundary line. And there's an aerial as well. And then just to go back over sort of an overview of the requests and the variance criteria, the dual frontage prevents the ADU from being located behind the principal structure. Oh, okay, yeah. Because of that through lot, either way, you're in the front yard. And it's consistent with the intent of the zoning district, as ADUs are permitted in the R4 zoning district. A literal interpretation of the ordinance would require removal of the ADU, which would put an undue hardship on the owner. And then the request is the minimum necessary to allow us to resolve that outstanding code violation. And again, as was previously mentioned, it's been on the property for almost 40 years, so we don't believe it will injure the surrounding area. And that is everything.
Okay, any questions for the applicant? Mr. Costa?
Yeah, quick question. This was a garage previously, correct?
Yes.
Built with the house originally? And
Yes,
then
it was
converted to
built
an
2
ADU?
years later.
Okay. All right, that's all I need to know. Thank you.
Yep.
Okay, I don't see anyone else on the list, so do we have any public participation on for this one? Ms. Summers?
No, sir.
Okay. We're going to close the floor for public participation and open it up for commission discussion or a motion.
I'll be glad to make a motion.
Go ahead.
I move that case number V2510, variance be approved, subject to 2 staff recommendations.
Okay, I've got a motion on the floor from Ms. Shelley to approve variances 1 and 2 for V25010 with the 2 staff conditions, and a second for Mr. Sixma. Any discussion on the motion? All those in favor signify by saying aye.
Aye.
Any opposed? Motion carries unanimously. Okay, that finishes the old business, so we're going to move right into our new business. Ms. Shelley, could I get the first case, please?
Yes, case V-25-015, variances to the minimum yard requirements on urban mobile home MH5 zoned property.
Thank you, Ms. Shelley. Ms. Ray, this one's yours also.
Good morning again. So the applicant is requesting 3 variances to resolve a code violation. Variance 1 is to reduce the west side lot line from 15 feet to 0 feet for an existing dock. Variance 2 is to reduce the east side lot line from 15 feet to 0 feet for an existing boathouse. And variance 3 is to reduce the north waterfront yard from 25 feet to 11 feet for a proposed deck. The property is a canal front property located on the north side of Lewis Street. It is developed with a mobile home that was constructed in 1974 and is developed with a boathouse and a wood dock that were constructed in 1978. According to historical aerials, the dock received hurricane damage in approximately 2017. In 2019, the applicant began making repairs without a permit, but did not become a code violation until 2021. The applicant did apply for an after-the-fact building permit in 2022, and that's where it was discovered that the encroachment into the side lot lines for the existing dock and boathouse. The applicant is also proposing a new deck over the existing boathouse that is proposed to extend southward over the land, encroaching into the waterfront yard. Staff's recommendation for variances 1 and 2 is for approval, as the variances met at least 3 of the 5 criteria. And variance 3 is for denial, as it fails to meet 3 of the 5 criteria. I do also want to note that we received 1 letter of support from an adjacent neighbor to the south, and I'm available for questions.
Thank you, Ms. Ray. I don't see anybody. Oh, Mr. Costa.
Yeah, I have a quick question for you. On variance 3, so there's an existing deck there now currently?
No, sir.
There's not an existing deck or dock rather?
The boathouse is existing,
Mm-hmm.
but where they're trying to extend over the land, that is not existing.
So the 11 feet that you're showing that they want to go on variance 3, there's currently nothing there,
There's a boathouse there currently.
boathouse there.
Yes, sir. But to be able to extend from the boathouse landward, they would need that variance to the waterfront yard because it's going past the boathouse.
Okay, I got you. I understand it now.
Okay.
Thank you.
You're very welcome.
Mhm.
Okay, I don't see anyone else. So is the applicant here?
Sorry, I can barely hear.
Okay.
Part of getting older, I guess.
Good morning, sir. Could I get your name and address for the record?
William Porter, Porter, 192 Lewis Street, Edgewater, Florida.
Okay, you've heard the staff report. Is there anything you would like to add to that this morning?
I'll say that again, please.
Said you've heard the staff report. Anything you'd like to add to it this morning?
Sir, yes, sir. I sort of heard it, but I read it before I came in.
Okay.
What I understood was that it's approved for the setback because it was built in 1978, the docks.
Mm-hmm.
Actually, it adjoins the dock next door to me as well. That's on the west end. But as far as the boathouse goes, it had the deck on top of it in 1978, And your records show that it's a deck. It was built in 1978, and it was a 10 by 14. Then it shows that the boathouse is 10 by 20. Well, at one time, the boathouse may have been 10 by 20, but it had a wooden ramp that went into the water as far as the 6 foot from the seawall, so you could put your boat on it and pull it right into the boathouse. That fell apart before I had a chance to fix it. So I think that's what they call a 20 foot, because right now the boathouse is 14 by roughly 10 by 14. But on the records it says it's 10 by 20. But it also says in there that the deck is 10 by 14, and that's the deck on top of the boathouse. And what I had proposed was to extend the south end of the deck where I could be on top of my first retention wall so that I wouldn't have to step down and then step back up. I have a disabled son and I'm getting old, so I wanted to be able to just walk right on it. It had a ramp, but I didn't repair the ramp in time, so it fell apart when this other stuff started falling apart. So originally all I wanted to do was repair the dock that was in the center of the yard at the seawall, but somebody turned me in for putting the boards on it. So I guess.
Okay. So these three variances going to address your concerns and be able to do what you want to do there. Is that correct?
Yes, sir.
Okay. All right. Okay. Mr. Costa, you had a question?
Yeah, one quick question for you. This proposed dock does not go further out into the water. It's only going across your property line, correct?
Yes, sir. The same post and everything are there.
All right, thank you.
Yes, sir. Thank you.
Okay. It doesn't look like we have any other. Oh, wait a minute. Ms. Shelley?
I forgot. When you came to the podium, this is just for clarification in my head, I believe you said your address was 192 Lewis Street?
That's where I live now. I lived at 123.
Okay, so this is your property and you are got you. Okay, thank you.
Couldn't live there. It wasn't safe to go to the water anymore, so.
Thank you.
Okay. Mr. Porter, have you read the three conditions that the staff recommended in the packet here?
I read where it had been approved for 1 and 2, which was the two
Well,
sides.
no, I'm talking about if in the event when this was to go forward and to be approved, you've got three conditions that you abide by for the variance in the packet. Did you read those?
I probably did, but I don't know. Could you refresh my memory on those?
Okay, basically it says variance 1 through 3 are limited to the size and location of the dock, boathouse, and deck as depicted on the variance site plan. In other words, whatever you put on there, you can't make any larger. It has to be within the boundaries there.
Absolutely.
And it also says the applicant shall obtain all required after the facts permits within 60 days of variance approval for any unpermitted structures. So now you're going to have to get permits for those unpermitted structures that you've done. Is 60 days going to be time for you to do that?
It should be, but I don't have any unpermitted. They're already there. All I'm doing is replacing things that were there.
It requires a permit though, sir.
But it requires a permit to replace what has
Yes.
fallen down.
Yes, sir.
Okay.
Okay. So you're going to have to apply for these permits and they're giving you 60 days to do that.
60 days.
Is that sufficient time for you?
Well, I have to re-get an engineer again and change things like that. So for the plans I already sent in, have the dock, but I guess we're not approving my deck extending out.
Yes, sir. It's all in the same application. On the variant site plan, it shows the dock, the boathouse, and that deck. So what your engineered plans that you've already submitted,
Yes.
that's what we have here for it to be approved, so you can submit that with your permits.
Okay,
Yes,
you're
sir.
going to see if we can approve that.
Yes, if it gets approved here, you'll take that.
Yeah, you'll have to
Yes,
get your
sir.
permits for that.
I apologize for my hearing.
That's fine. I just want you to be clear what you have to do after this moves forward. And it will also require a wetland alteration permit will be required that impacts any wetland buffers. You're aware of that?
Yeah, I was, someone told me that once I got this approved, that we could put them all together
Okay.
and get it all done at once.
Well, I just don't want you to leave here thinking that it's all said and done. There's other things that you need to do to move this forward, okay?
Okay.
All right, Ms. Shelley, you had a question?
No, I'm fine.
Okay. Do we have any public participation forms for this case?
No, sir.
All right, sir, we're going to close the floor for public participation, and we're going to make our decision now, okay?
Okay.
All right, thank you. Okay, we're closing the floor for public participation and open up for commission discussion or motion.
Something I'd like to ask is can we make, I know we got the 3 staff conditions on here. If I do make a motion on this, could we change 60 to possibly 90 days?
We can,
More time?
if that's what your motion would
Yeah,
like to
because
add.
the way things, who knows if that'll be enough time. Okay, I will make a motion for approval for case V 25015 with the staff 3 conditions, with number 2 being extended from 60 to 90 days.
Second.
Okay, I got a motion on the floor for Mr. Sixma to approve variances 1, 2, and 3 for V 25015 with the 3 staff recommended conditions, with the amendment to make the recommendation number 2 from 60 to 90 days. Any discussion on the motion? Ms. Shelley, are you still wanting to talk? Go ahead.
No.
Okay.
Why is this on here?
I'm going to reset
Thank
it
you.
right now. There we go. Okay. Okay. All those in favor signify by saying aye.
Aye.
Any opposed? Motion carries unanimously, sir. All right.
Thank you.
Good luck. Ms. Shelley, could I get the next case, please?
Case number V-25-017, variances to the minimum yard requirements on urban mobile home MH5 zoned property.
Ms. Ray, this one's yours also.
The applicant is seeking two variances to replace an existing dock. Variance 1 is to reduce the west side lot line from 15 feet to 0 feet. Variance 2 is to reduce the east side lot line from 15 feet to 0 feet. The owners purchased the property in 2024. The subject property is currently vacant except for the existing dock and boat lift. According to historical aerials, the dock received hurricane damage in approximately 2016. According to the applicant's written petition, the replacement dock is proposed to be located within the same footprint of the existing dock. The existing boat lift is proposed to be demolished and replaced with a boat lift that is smaller in size. The variances are unlikely to be injurious to the area, as there are adjacent properties that have docks similar in size, and they are replacing the dock that has been in place for about 20 years. Staff's recommendation for variances 1 and 2 is for approval as the variances meet at least 3 of the 5 criteria. I'm available for questions.
Thank you, Ms. Ray. And we don't have anybody want any questions, so is the applicant present? Good morning, sir. Could I get your name and address for the record?
My name's Ken Anderson, 817 East 9th Avenue, New Smyrna Beach, Florida, 32169.
All right, sir, you've heard the staff report. Anything you would like to add to it?
No, sir.
All right. Any questions for the applicant? We don't see any. Do we have any public participation forms for this case?
No, sir.
Okay, we're going to close the floor for public participation and open up for commission discussion or motion.
Thank you.
I'll be glad to make a motion.
Go ahead, Ms. Shelley.
I move that we approve case V-25-017, subject to 1 staff condition.
Second.
I got a motion on the floor for Ms. Shelley to approve variances 1 and 2 for V-25017 with the 1 condition from staff. And a second for Mr. Sixma. Any discussion on the motion? All those in favor signify by saying aye.
Aye.
Any opposed? Motion carries unanimously. Ms. Shelley, could I get the next case, please?
Yes. Case number V-25-018, a variance to the minimum yard requirements on urban single-family residential R9 zoned property.
Thank you, Ms. Shelley. And Mr. Shams, this one's yours.
Hi, good morning. To begin, I'd just like to establish the proposed variance is only applicable to the waterfront yard. If approved, the variance would permit a buildable area and would not supersede any other requirements. So the applicant's home was destroyed during Hurricanes Ian and Nicole and is currently being reconstructed. You can see the reconstruction on your screen right now. It is seaward of the coastal construction control line, which requires additional permitting and review by Florida Department of Environmental Protection. The applicant obtained an approved permit for the new residence with a 4-foot retaining wall and a permit for the concrete seawall. As a condition of the permit, a 25-foot wide area between the home's retaining wall and the concrete seawall is a stormwater drainage swale. Per the county code, the waterfront yard begins at the concrete seawall. The applicant is requesting a variance to reduce the waterfront yard from 25 feet to 14 feet for an 11 by 11 deck extension. According to the applicant, the deck extension will be attached to the 4-foot retaining wall and step down into an enclosed seating area that includes built-in seating and a natural gas line for a fire pit. The applicant also intends to place fill dirt on the landward side of the retaining wall for stability. Overall, staff recommends denial as the variance does not meet any of the 5 criteria. If PLDRC finds evidence to approve, staff recommends 2 conditions. And I'm available for comment or question.
Thank you, Mr. Shams. I don't see any questions. Oh, Mr. Costa, yeah.
Quick one here. So this variance that they're requesting, so the house was destroyed during the hurricanes. Was this deck existing prior to? Part of the house that got destroyed? Or is this in addition to what was there previously?
So I believe the retaining wall was there, which is being rebuilt.
Mm-hmm.
The applicant can provide further information on that. But
And-
as far as what he's proposing, that's new.
And can we go back to those construction pictures, please? All right, so that is the house as it currently sits right now and during construction?
Yes, sir.
And so if I'm looking at this picture correctly, the back of that seawall, the deck that we're talking about extends outward from there?
No, sir. It extends closer to the home.
So inward of that wall?
Yes.
Okay, so if I'm looking at this correctly, then that seawall there is actually behind both the properties on the left and the right of the picture? Or is that an optical illusion? They're behind both those wall lines, correct, on the left and right?
Yes.
Okay.
That's correct.
Thank you.
So the clarification here again is this, he's not going exceeding the seawall. Is that correct? The seawall is a setback point?
The seawall, as you see it right there, is where the waterfront yard begins. Then it moves towards the home. So
And previously with that new seawall being built, was it further out?
I believe so. This is an area that experienced a lot of erosion. Because they applied for a seawall, it is the DEP that dictates the location of that seawall. So it's not the county. So if I recall, this property had more land seaward of the structure. But because they obtained a seawall from the DEP, the seawall is now the measurement of the waterfront yard.
Okay. And this variance, Mr. Soria, I'm looking at the staff conditions. It's limited to the size and location of the actual
Just the deck.
request that he's planning on building. In other words, he can't go and put another building or anything in that variance.
Yes.
He can?
No, he can't. It's basically asking just for this.
Just specifically for what he's requested. Okay, that was my question. Okay. Is the applicant present? Good morning, sir. Could I get your name and address for the record?
Sure. Good morning. Ken Meister at 4227 South Atlantic Avenue.
All right, sir, you've heard the staff report. Anything that you would like to add to it?
Yeah, I just want to clarify one thing, that the requested variance would be off of the retaining wall. So it wouldn't come off of the question you asked was off of the seawall seaward, it wouldn't even come off of the seawall landward. It would start from the new retaining wall that's 25 feet landward of the seawall and then extend 11 feet towards the water. And so, in essence, as you can tell by the pictures, I lost 32 feet of property when the DEP made me locate the seawall 32 feet landward from my neighbor's seawalls. So I've lost not only the 32 feet of property, but then with the 25-foot setback, I lost a lot of property. So I'm just trying to gain a sitting area. I could have asked for a larger variance. I kept it to 5% of the setback. I think it's reasonable. It's all on my property, and any concrete structure there is going to be even further landward than my neighbor's concrete structures. So it's just basically an impact of the hurricane. I'm just trying to get some backyard back.
All right, sir. Any questions? Do we have any questions for the applicant?
Yeah, I'd like to say something. So
Go
your
ahead.
existing seawall was farther out before the hurricane?
I didn't have a seawall.
Didn't
I
have
just
one.
had dunes.
Okay, you wouldn't have one after a hurricane either. To tore it up, but, okay, good, thanks.
All right. Do we have any public participation for
I
this?
have a question. I
question.
have a question.
Oh,
Oh, we're supposed to
If you just
request,
hit your-
request speak button now.
there
Yeah,
you go.
I pressed it and left mine on.
Thank you. What is the deck construction material? Is it wood?
It's
or is it-
probably going to be a wood. We haven't finalized that yet because we were just waiting to get past this phase. But most likely it's going to be a wood material.
So it would have piers down into the sand?
Yeah, there'll be drainage into the sand.
Okay, thank you.
Mhm.
Okay, we don't have any public participation forms, so we're going to close the floor for public participation, open up for commission discussion, or maybe even a motion at this time. Okay? All right, thank you, sir. Okay. We are closing the floor for public participation. I'm going to put it up for commission discussion or a motion.
I think I'm ready to make a motion.
Go ahead, Mr.
I'll make a
Sixman.
motion for approval for case 25018 with the staff's two conditions.
I got a motion on the floor from Mr. Sixman to approve variance V 25018 with the two conditions from staff and a second from Mr. Costa. Any discussion on the motion? All those in favor signify by saying aye.
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 Any opposed? Motion, okay. Okay, it's, 4-1 with Miss Craig in dissent. Okay. All right. Ms. Shelley, could I get the next case?
Yes, sir. Case number V-25-020, variances to the minimum yard requirements and maximum lot coverage requirements on urban single-family residential zoned property.
Thank you, Ms. Shelley. And this, Mr. Shams, also.
Good morning. So the applicant is seeking variances to allow reconstruction of outdoor wooden decks and wooden walkways to allow beach access. This is also a result of hurricane damage. The site is developed with a 4,000 square foot residence, originally constructed in 1960, and the current owner purchased the site in August 2023. The property is supported by a seawall along the entirety of the eastern boundary, the easternmost 35 feet on the northern and southern boundaries. According to the applicant, there was a previous deck area before. The property is seaward of the coastal construction control line and requires FDP permits. As you can see, there are four distinct structures being proposed. The applicant received an approved FDEP permit for the proposed work. R9 zoning class requires a 7-foot side yard and a 25-foot waterfront yard, and it also has a 35% maximum lot coverage. The property currently exceeds the lot coverage at 43%, and the proposed structures would increase it to 45%. So overall, they're requesting 5 variances. Reduce the north side yard from 7 feet to 0 feet for the wooden walkway and deck. Reduce the east waterfront yard from 25 feet to 4 feet 8 inches for a wooden deck. Reduce the east waterfront yard from 25 feet to 0 feet for the wooden walkway. Reduce the south side yard from 7 feet to 2 feet for the walkway and deck, and to increase the lot coverage from 35% to 45%. Overall, staff recommends approval as all 5 variances meet 3 of the 5 criteria, and we also recommend 2 conditions. Available for comment or question.
Thank you, Mr. Shams. Mr. Costa, you had a question?
I do. This is just replacing what was lost during the storm.
Essentially, the configuration is a little different, but it's very similar.
Square footage, the layout, I mean, not the configuration, but the square footage is the same?
Pretty similar, yes.
Okay, all right, thank you.
Okay. We don't have any other questions. Mr. Shams, if, in the event that this were flat work, if it wasn't decks that we're talking about, it wouldn't require a permit, would it?
Can you repeat your question?
If it was flat work, in other words, if this wasn't a wooden deck, if it was flat work, concrete sidewalk, it wouldn't require these permits, correct?
No, sidewalks do not.
Okay, that's what I wanted to find out. And also there again, I'll ask the same question I asked previously. The conditions, the staff recommendations is specific to this wooden deck, correct? In other words, another structure can't go within this variance.
That's correct, sir.
Okay, there we go. All right, is the applicant present? I'm just getting clarification on that, you know. Good morning, sir. Could I get your name and address for the record?
Good morning. Yes, sir. John Sharp, 3660 Old Oak Court, Orlando, Florida, 32812.
All right, you've heard the staff report. Anything you would like to add to it?
I'd like to add that I wholeheartedly agree.
Okay. It doesn't look like we have any questions for you, so do we have any public participation forms for this case?
No, sir.
Okay, we're going to close it down and see if we can't get you
Get moving. Thank you.
get you moved.
Been a long time.
Moved on. All right. Closing for public participation and open up for commission discussion or a motion.
I'll be glad to make a motion.
Go ahead, Ms. Shelley.
I move that we approve case number V-25-020, variance to the minimum yard requirements and maximum lot coverage requirements on urban single-family residential R9 zoned property, subject to 2 staff conditions.
Thank you, Ms. Shelley.
Second.
Okay, I've got a motion on the floor to approve variances 1, 2, and 3 with the 2 staff conditions from Ms. Shelley for V25020 and a second from Mr. Costa. Any discussion on the motion? All those in favor signify by saying aye.
Aye.
Any opposed? We good? Motion carries unanimously. Okay, Ms. Shelley, could I get the next case, please?
Case number S-25-001, a special exception for a recreational area on prime agriculture A1 and resource corridor RC zoned property.
Okay, this has also got a companion
Yes.
case with it, so we might as well hear both of them.
Yes, sir.
You
Case
want to
nu-
read that one in too, please?
Case number V-25-023, variances to the minimum yard requirements on prime agriculture A1 and resource corridor RC zoned property.
Thank you, Ms. Shelley. And Ms. Smith, this one is yours.
Thank you. This is a special exception for a recreation area on prime agricultural property. That's A1 classification. A special exception is a use that would not be appropriate generally or without restriction through a particular zoning classification, but that would not adversely affect the public health, safety, comfort, good order, appearance, convenience, morals, or general welfare, if controlled in number, area, location, relation to the neighborhood, or in other appropriate respects. So a recreation area is allowed in the A1 zoning classification with an approved special exception. And a recreation area is defined as a privately owned and operated facility providing recreation and sport uses such as golf courses, country clubs, swim clubs, tennis clubs, and the like. A private recreational facility is generally sustained through the sale of memberships, but it may be open to the public for a fee. The property owner has been operating a dog diving, dog training facility at her residence. It's a 10.56 acre parcel with business activities occurring near the southern boundary and access from Marsh Road. Code compliance received some complaints from the neighbors, and the owner was issued a code violation. They need to cease operations until that case is resolved. The owner can resolve the code violation by getting a special exception for a recreation area and abiding by the conditions outlined in the special exception. The property is split zoned A1 and resource corridor, but all the activities are limited to the A1 portion of the property. Activities include individual dog training lessons on a daily basis and dog diving competitions throughout the year. The facility is open 7 days a week from 10 a.m. to 5 p.m. Weekdays are used for individual dog training appointments. Competitions are held over a 3-day period, Friday through Sunday, with an opening of 8 a.m. to allow for registration at the diving events. No overnight camping is allowed. So for traffic generation for weekend events is approximately 120 trips a day. Traffic for daily appointments ranges from 6 to 24 trips a day, and a typical single-family residence generates about 10 trips a day. Recreational facilities require all structures to be at least 50 feet from the property line. The pool and the shed used for the business are less than 50 feet from the southern property line, and the applicant is requesting variances for these structures. Variance 1 is for the above-ground pool, which is 44.1 feet from the property line, and variance 2 is for the shed, which is located 12.3 feet from the property line. The pool was permitted as a residential structure, which was allowed to be located 8 feet from the property line. The shed could be located 5 feet from the property line if it was being used for residential purposes as well. The building official determined that the pool should be permitted as a commercial structure since people and dogs are coming to the property and the pool is being used for business purposes. We do have letters of support and letters of opposition that have been received for this application, and they are in your packet. The adjacent neighbors most impacted by the business did submit letters of opposition. So in reviewing the variances, staff recommends denial because they don't meet at least 3 of the 5 criteria for granting variances. We also do recommend denial of the special exception application because it does not meet all the special exception criteria. And based on the letters of opposition, it appears to adversely affect the adjacent neighbors. If the PLDRC finds that the application meets the criteria for a special exception, we do have 12 conditions that have been provided on page 8 of your staff report for your consideration. And just a reminder that if the special exception is approved by County Council, the applicant still needs to go through the final site plan process to ensure that parking, stormwater, landscape buffers, fire and building requirements, and other special exception conditions are in place prior to reopening the business. I'm here to answer any questions, and the applicant also has a presentation.
Thank you, Ms. Smith. I do have a few questions. On your 12 recommendations, it's limited to 30 dogs. How are they gonna, how would code enforcement enforce this? How would that be obtained? How will we know if they got 30 dogs or 50 dogs there at an event that's done on the weekend?
It would be through complaints through the code process. We did put a limit on dogs because there was a recent case that you all heard for a dog training facility that you did have a cap of 30 dogs on. That wound up having a lot of complaints, and ultimately they were closed down as a special exception because they didn't keep that limit. We were advised to put a limit on here to avoid that problem in the future, but you are welcome to change that number to whatever you all think is appropriate.
No, it's not the number. I'm wondering how it's going to be enforced.
Code enforcement would have to go out
There
there.
would have to be a complaint, and
Yes, sir.
on the weekend, and code enforcement usually doesn't work on the weekend, correct?
And neighbors could submit photos and things.
Okay. The other thing is, it says no loudspeakers. Does that include megaphones and stuff like that? Any?
Yes, sir, that is a
Audible
special
devices?
condition. That is a criteria of the recreation area.
All
You're
right.
not allowed to have amplified sound.
Okay, I'm curious to see how they're going to communicate without it. So, okay. All right, thank you. Is the Mr. Costa? Oh, Miss Craig, you
I had a question
go ahead.
about signage for traffic.
I need to pay attention.
Can you turn your mic on, please?
Sorry.
I'm concerned about the traffic problems that could be resultant. Are there any requirements for signage on, since this is a curved road?
We did not include signage requirements, but you can certainly add those as conditions if you so choose.
Thank you.
Mr. Costa?
Yeah, there's, on your conditions or recommendations here, this is a public and animal event, correct? People and animals at the same time, correct?
Correct.
No requirements for facilities, bathrooms?
We can ask the applicant how they've been handling that in the past. They have been in operation, but we can add specific requirements if you would like.
And I also know that in cases where we've had wedding venues, for instance, and parking, there was always a condition about ADA parking. I don't see that on this list of items either.
That's a requirement for building that
For
will
building?
have to be.
Okay. All right, thank you.
Okay, don't have any other questions. So is the applicant present? Good morning, sir. Could I get your name and address for the record?
Of course. Joey Posey, 420 South Nova, attorney for the owners. And I don't know how to move through this. Thank you. Alrighty. Oh, I don't see the presentation. And I guess while the presentation's coming up, I'll just jump into it. And a lot of these concerns actually are outlined in the concept plan that we submitted. It does show ADA parking. I just asked to be sure that we have porta potties, and we also are going to ensure that there's an ADA compliant porta potty out there too for all the guests that want to come out there and if they have those needs. But I do want to maybe highlight some important parts and walk you through how we got here a little bit and maybe the nature of what they do, because I feel as if the nature of their business is maybe been a little bit misrepresented, and putting it on the record and trying to make sure we have just open and honest conversation about what these folks are up to, I think would be very helpful. So just the background, as I think Trish indicated, it is A1 property. And just to be clear, in the A1 property, permitted uses such as outdoor entertainment events are permitted use. And if you look at the definition of the code, any activity designed to attract 500 or more persons per day, 1 or more days, for the purpose of listening to, viewing, and or participating in outdoor entertainment conducted in open space outside of an enclosed building is a use by right. You have the ability to do it just by the nature of being in an A1 zoning. Also, there's the zoning category allows the limited boarding of dogs, and just as a permitted use, you don't have to go through a special exception. So just to give you a flavor of what's allowed out there, because this is a little bit of a rural area, and I recognize that some of it is residential, but there are activities that are just permitted by right that you're allowed to do on your property. The mention of the 30 dogs, that was something that came out when I read the staff report. I wasn't aware of that until I read it, but which is fine. This isn't a kennel, just to be clear. It's a venue that folks can come and go at appointments during the week, few appointments a week, and they have periodic events that they advertise for, that they try to encourage participation in, and it's not an every weekend thing. At most, it's 8 or 9, and that's one of the conditions I think that's mentioned in the special exception, that these are very infrequent. So to move, it's like, I don't know if I'm doing this right. Oh, there we go. How we got here. The property owner attempted to get a pool permit in 2023 for diving and swimming lessons. It was conveyed to staff. That was always their purpose. It wasn't trying to hide anything. These folks are just your normal average Joes that went down and tried to pull a permit. And, the only clarification and guidance they were given was the lack of guardrails on the pool. And just looking at the pool, you can tell by its nature a little bit that it isn't your normal residential pool. And even staff was encouraged to attend events talking about what they're up to, what they want to do, how they want to do these events out there. And just the periodic appointments. And at no point was the representation changed. The pool and the dock were always going to be there for dog diving and swimming lessons. So it's permitted. It has an actual permit. It just unfortunately went through a form of permitting that was a miscommunication and a misunderstanding as to what the nature of the swimming pool was. But that doesn't change anything on the applicant's end regarding their intent, that they've always wanted to do this. They're happy to. If there's additional requirements that come from commercial permitting, happy to do it. It's not a big deal from their end because this is always what they intended to do. And I think, if I remember correctly, that the neighbors were even aware of the situation and invited onto the property to see what they're up to. So it just didn't happen and everybody woke up one day and there's a pool there. Looking at the special exception criteria, the separation requirement of 50 feet, which is unique to the activity center special exception, that would be a permitted structure otherwise. So, and I do recognize why the 50-foot boundary would be important. Unfortunately, the pool and the footers went into the ground through a permitting process, and they've been trying to do their best based on feedback they received to try to be accommodating as possible, to minimize impacts, and the presentation is going to get into it a little bit of a lot of those mitigation measures that they've taken. And if you look at the surrounding area, also too, just highlighting structures around the immediate area, I think most of the properties suffer from the same problem when it comes to side yard setbacks. So it's just a little bit of the nature of the area. And they were also trying to be conscious of everybody around them by trying to get into that upland acreage, trying to isolate it in an area that's accessible, and just to be respectful and in a way that tries to address the concerns that we've been hearing in terms of potentially that there may be noise concerns, and that's great. We're happy to take that off the table and remove microphones, loudspeakers, and it looks like, and just as my rough estimate, there's a few hundred feet away from the nearest structure, but I can't tell really from the aerials other than that. And we have no issues with the staff recommended conditions. See, even the additions that were added. The whole goal here is to be a periodic appointment only dog facility for dog diving. They're very passionate about it, and have the periodic events on the weekends, which are noticed. Everybody knows they're coming, and just to stay accountable. And the variance by necessity, that's why we're here with the variance too, that the location of the pool, because of the special exception, tripped the variance criteria, which has required us to get a variance for the pool. The shed also too would need a variance, which is simply for the storing of their equipment on the weekends. It's not a very large structure, and to be honest with you, if that is something that we can do to be accommodating, we're happy to talk through what may be some options to further limit the impacts. And like I had mentioned earlier, there's no issue with addressing the safety and structural issues that have been alleged, even though we're fairly confident that this pool has been over-designed, that would be through the county permitting process. To clarify also just how, maybe some of what you may hear is, the first event took back in July. That they were very excited to do it. They had friends out there. There were 2 RVs that came out that were friends of the actual family. After it was made clear that they were not allowed to have RVs, there has been no RV since, and that will be the rule moving forward. The same is true of a food truck. That there was a local person that came out there with a food truck at the July event, and the July event, we heard the complaints. They responded immediately, and there has not been a food truck since. And the notice to hearings, as you can tell, and you can see the timeline, it moved fairly quickly. And the problem that they ran into with their August and September events is that, funny enough, the dog diving activity itself has a competitive permitting process through in North America, and you have to schedule your events a year in advance. So there was no opportunity to cancel those events in August or September, but as of the October hearing date that we had for co-compliance, there has been no events since. So, they're trying to do the right thing, and this is something that they do as really what they're passionate about. That this is what they want to do, and I do feel for them a little bit that there is a financial hurt when it comes to these kind of things, because it's and I can imagine from as you guys see from your perspective, it's hard to have those conversations when you rely on this a little bit for your income. But moving forward, again, the hearing was in October. They've addressed even future, moving forward with future events. There was one that I think was alluded to in the staff report in March, but that was with the anticipation that we would be done with this process by March, so it's not happening. It's dependent on us moving through this process. There, again, no food trucks, like we said. The obedience training, if there is any that requires, something beyond just the normal things you would do associated with dog diving, then it's done off-site. There's nothing like that happening at the facility. And just to maybe dispel some rumors that may be floating out there that, events are every weekend, and no, it's not. It's 8 to 9 at most, and I think the staff report specified 9, if I remember correctly, as the cap. And they're weather dependent. There's loud music all the time. Again, they were very quick about not doing any audible sound after they heard the first complaint. There will be no food trucks. This was an RV event. There's no RVs that are allowed. And here's just an example, and we even invited county staff, if they wanted to attend, to see what one of these looks like. And this was in August 2024. Really just, it's a very informal setting, and it's dogs diving into a pool. That's really the sum of it. And they've been trying to do their part too by reaching out to neighbors. They've done a lot of their homework, and I think that there's 9 folks on Marsh Road that they've reached out directly that get support from, and about 15 others in the immediate area. And these are in addition to your staff report letters, and also some local businesses, and one even on Marsh Road. That recognizes the benefit of something like this in the community, and another letter from a New Smyrna Beach facility that runs a similar operation that also does the same thing. And it's not a very large and grand event. It's dogs diving into a pool and periodic lessons that happen during the week for the training associated with it. So. I'm happy to answer any questions. We really want to do the right thing, and if there's ways to limit this, we're happy to do it. I just wanted to make sure it was clear that these folks are not trying to run a big grand event or facility, and that some of the things that may be allowed by right, they're not looking to do that. They just want to do something that's limited. It has very tight conditions to it, and that if there's anything we can do to help, that's why I think all these folks are here over here to just voice how much they do appreciate and what they're doing, because there's a lot of benefit that people can come out and enjoy these type of events. So I'm available for questions, or if there's anything I can clarify that wasn't touched on.
Okay, Mr. Costa, you had a question?
Yes, good morning.
Good morning.
Can you go to your slide number 10, the beginning of the clarifications and rumors?
Yeah.
Your very first line. This is not a dog training facility.
Yes.
First line on the case number 25001 is recreational area to operate a dog diving pool and a training facility. So which is it?
It's the implications of code compliance, the code definitions. Where all they're doing is dog diving, and there's appointment trainings, if you want to call it training, associated with the dog diving. And they've got a frisbee area, and I think if you go out there, you'll see some little gymnastics area for the dogs, but that's really it.
So do they train dogs Monday through Friday and then have diving events on the weekends, or no?
If you're saying training as in
they're teaching them how to dive.
That's correct. And
So
that's
training.
That's a fair assessment. I just want to be careful with saying that it's training as if it's it's being associated with, for instance, the canine facility that was alluded to over here.
Yeah.
Correct.
Totally different.
Right. Honestly, when I first read this, I thought it was a joke. It's like dog diving. What the heck? I had to look it up, and it's a thing. It really is it's a big thing, actually. It's not a small thing. The other question I have is, there is a picture that's been submitted, and actually it may be on the very first page of your layout as well, if you can go there.
Over here?
Yeah, that one doesn't really quite show it. It showed the property line, showed the pool to the relationship to the property line with the adjacent neighbors. It looked like to the below them. I'm going to assume that's to the south.
This one?
Yep, that one. And actually, there was a picture that was submitted. But regardless, the only thing separating those two properties right there in that picture is a chain link fence. Is that correct?
No, it's a 6-foot fence now.
There is a 6-foot fence there now?
Yes, we, out of courtesy to the neighbor, they've installed a 6-foot fence.
As of
A month ago? 3 weeks ago?
3 weeks ago?
Yeah, final fencing.
See if this picture has a date on it, and it does not. Okay. That's all I had. Thank you.
Okay, I've got a, Ms. Craig, you had a question?
When you were reading about the definition of the A1 zoning, it mentioned boarding of dogs being allowed. Is there any possibility that this could turn
No.
into a?
No, 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 no. And I'm happy to put that in the conditions too, if it needs to be explicit, but there's no intent to board them, and there will be none. So I only brought it up just to give a sense of what is possible and what's allowed by right in the zoning category, just because of the, the nature of the use, and, in terms of outdoor events, in terms of boarding of dogs by right, those discussions don't happen here. This discussion's happening here because of just the nature of what outdoor rec and its definitions are, and I just wanted to make that clear for the record.
Ms. Shelley, you had a question?
Yes, I have a couple of questions. When did the owners purchase this property?
Ooh. 96?
And how long has it been operating in this capacity?
Uh,
Well, the diving and what you're doing.
Sir, I'm gonna have to
What-
get you to come
Yeah,
forward
he can
and,
put his name on the record.
Yeah.
please.
yeah, you
and-
need to put
and
your name and record and for your comments.
July, correct? July, correct.
My name's Fred Ford. I live at 3098 Marsh Road. And as far as this, what we're doing now, was July 1st, was when that was completed and we opened it up, then we had our events. We have not been doing the dock diving prior to that, no.
Okay. Have you been having events on this property prior to that?
No.
Interesting, because some of the letters, I've been attending these events for years, was in one of the letters. I was just wondering.
Yeah, well, I think they were talking about, in general, dock diving events, not our
Oh,
dock
not
diving.
particularly on your property. Okay, thank you for that clarification. So you purchased the property in
93,
93, and you've started doing the pool diving in what year?
2024.
2024, just can't, okay. Got that on there. Okay, the other thing I was gonna ask, I was trying to write notes along here as we went. Okay, so no lighting because the activities are all in the day.
Yes.
Okay, and then I would just say, from my perspective, in reading through the report, all the letters that were submitted in support, the majority did not have addressed. They were more like conversations. And it would be really good for our point of view to have the person have their name and address submitted anytime they're doing something. And there were not a lot of addresses in what I received regarding this. And like on your petition, it says cities, lots of cities and all that, but their addresses. And then you're not going to have any food trucks or outdoor sound. I'm sorry, there was another question I wrote on here when Joey was talking. Oh, the discussion on, and I heard Mr. Posey say that there would, shook his head on, or mention the canines a little bit, because that also was included in here. So, so you're not planning on doing canine training on your property? Meaning police?
No.
Law enforcement
No.
animals. Okay. Thank you.
Mr. Costa?
Yes. Back to your presentation, page 1, please. That one right there.
Mm-hmm.
So, if I'm reading this correctly, you're telling me that the definition says not more than 500 persons per day.
Correct.
on a 10-acre parcel
As permitted,
as permitted.
yes.
It's a lot of people,
Yeah,
potentially.
agree.
On the first event that you had, roughly how many people attended? Approximately.
For the weekend,
Well, just in a particular day, in a 24-hour period.
we estimated it to be about 40, 45 people.
Okay, so under,
That's throughout the day. They come in the morning, some come early, some come later. They don't come and stay and do things all day
congregated at one
long.
point was less than 50 people, say?
Yes.
Okay.
My concern.
All right, that's reasonable. Then the other question I have is regarding the swimming pool, because we have the companion here is the yard requirement. So when the swimming pool was originally put in, was the intended purpose for this?
Yes. Yes, it was. And we talked to the permitting office, explained what we were trying to do in hopes that we would get the proper direction. There was some miscommunication or something for some reason, and they said, well, here's what you need, residential pool, da-da-da.
So they gave you the residential pool setbacks as opposed to
And residential pool permitting.
okay, that's what I wanted to find out. All right, and how long ago was that?
That was October 2023 was when we finally got the permits approved to go forward. And then the final inspection was on all of it. I believe it was May, could be earlier than that.
Of what year? Of what year?
2024.
Of 24, so, okay. So, and you didn't have your first event until the
July.
July of 24?
Right.
All right, and then here we are today. All right, that's it, thank you.
Mr. Soria.
Yeah, I think this board should, and with Mr. Posey, should clarify the training aspects because we, staff took the cue based on, their historical use and their advertised use. So they are advertising, training, basic obedience, service dog skills, dog swim lessons, dog diving lessons. Occasionally they have competitions, that's the event. But they also state on their flyer, they work with local shelters. They're planning, this may not actually happen, to offer their services to police and fire departments to allow them to train their canines. So there is a kind of training aspect. It's just you may want to clarify on what that kind of looks like, but that's why the special exception is written as it is to account for, I don't know if it's training the dogs to jump into the water is the training position, but that's kind of what staff is looking at.
Okay, thank you, Mr. Soria.
Oh, and I don't mind clarifying if you'd like.
Go ahead.
I was just talking this through, and I think it's fair to say that, there is general obedience in some of the aspects. It's fair to say that, if it's for dog diving or not, that, there is some obedience and it doesn't have to be dog diving. But it is for individuals. That's all they've really ever had, and I think in terms of folks that are booking these appointments. So, it's, anybody who wants to come in and train their dog and get the dog diving, that's really the intent. It's, the partnerships would be great, but that's not the nature of the special exception, and, nor what is in the intent of the special exception for this application.
May I?
Go ahead, Mr. Costa.
Let's go back to this training, the individual one-on-one. So you're not boarding any animals overnight to train?
No.
They're brought in, it's almost like a daycare. The owners are bringing the dogs in, you're working with the owners and the animal at the same time?
Owners and the animal.
Simultaneously?
Usually would be like an hour and a half, do some work, and then they go home and work with what we've shown them.
In groups or in individuals?
Individuals.
Individual only?
Yep.
Okay, so maximum?
We used to have my Angel with Paws service dogs.
Okay.
At one point. And that's where we got started with the dog training.
Okay.
But we're just doing it just one-on-one.
By appointment only?
Right. Perfect.
Yep.
Okay, thank you.
Ms. Craig, you had a question?
Yeah, I'm curious about the national organization. Does it have any restrictions on the size of these events, or what are the normal, how large can these events grow to? I mean, I understand that this is a new enterprise, and so you said you had a peak of 45 people. Is there the possibility that it could fill up?
Well, the July event was way beyond what we really expected. It was busier than we thought it would be. And as far as I know, NADD does not have any restrictions on how many people you can do other than the amount of people you can handle getting done in a day. They don't want you running into the night. They don't really like lit pool because lighting at night doesn't light down into the pool. It's not safe.
So Fred, is it safe to say that they would take deference to the county requirements?
Absolutely, yeah. They would follow whatever the permitting in the area requires. I don't know of any that have gone really beyond what we did on July.
Thank you, Ms. Craig. Mr. Costa?
Yep. By chance, do we have this picture available to put up? Just want to get clarification on a comment that we made earlier.
If I could.
Are we waiting on the picture?
Yep, waiting on the picture, yep.
And while we're waiting for the picture, I did want to point out that in the PowerPoint, there are several other support letters with addresses that
Yes,
didn't
I saw
otherwise
that.
make it. So I just wanted to make
But
sure
they
you
were in
guys
the
are aware of
PowerPoint,
that.
which we don't have.
I do have physical copies
Because I
if you'd
saw
like
them
it.
on the screen. I was like, that would have been
Those,
nice.
those were in addition. These folks have been working hard.
Not coming up? Okay, that's fine. So if you take a look at that picture, and it doesn't have a date on it, that chain link fence is the one I was referring to. You're saying that's been replaced by a
Yes.
6-foot stockade fence of some sort?
6 foot vinyl.
Vinyl PVC? Okay. So now you have separation between the neighbors.
Goes along that property line and then along the front towards the road.
Okay, so it's blocked from the road as well as the neighbor itself. Okay, that's what I wanted to clarify. Thank you.
And a clarification on the, I guess NADD does, she's our NADD special, expert, does have a limit on number of splashes that you can do each day. And splashes is how many times a dog jumps into water.
Interesting.
Okay.
But that's per dog.
45? 45.
Okay, I've got a few questions here. You had a thing from additional area support, correct? Was any of those adjoining property owners?
Not immediately adjoining, that's incorrect. The only adjoining owners, I think, are the two that are jointly owned and one's a rental. The gentleman across the street was spoken to, and I can let Fred speak to that if you'd like, but I think the only person that wasn't reached was the northerly owner, but I think it may be a relative of the other owners. I'm not immediately sure, but the attempt was made.
Okay, but because we have letters of opposition from, it looked to me like all the adjoining property owners. You know, I'm just telling you about that. And the additional area of support that you had, none of those, would you say that the majority of those, I would say 90% do not live in the area, that area? Immediate area?
On several of those are like a letter from the person on the other side of the property south of us. There's letters from people further up the road by a couple of houses.
But I'm just saying, what I'm talking about is adjacent property
Not
owners.
adjacent to us, no.
Okay. Okay, and in one of the conditions, it said for the loudspeakers, okay? I don't know how many decibels that would be or considered, but when you have, let's say 20 dogs, let's don't even go to the maximum, 20 dogs there, excited dogs, and you got the barking and stuff going on, would you say that, because I know that I can hear a dog bark a long ways, a lot further than I can hear a loudspeaker a lot of times. And to have those 20 excited dogs there with the barking, how are you going to communicate the event without a loudspeaker or something to overshadow this noise of the dog barking?
Well, generally, it's information we post, like order of dogs on a board for everybody to know. We don't necessarily have to announce it to anybody that it's there. And it's a fairly compact area, and we can communicate. We have not had any problems since we stopped using the amplified speaker to announce things. As far as I know, it's just basically we'll holler out to people. And
in the statement you just said, you said it was a fairly compact area.
Where the dogs are and where the pool is.
Right. And so that compact area is actually on the edge of the actual 10 acres. So really, it's not like we're looking at this sitting in the middle of 10 acres, correct? No. And when you put up your event, I'm looking at a picture here where you had a temporary thing closer than what the pool is, and in that buffer zone.
A what?
Temporary umbrella.
Oh, yes.
So what the point I'm trying to make is you're bringing this event right next to adjacent property owner that has probably been there a lot longer than what this facility has.
Yes.
And so I agree that you should have property rights and everything, but I believe we all should take in consideration the adjacent property owner, that this is going to have to them, when maybe not to you or your supporters, an adverse effect for the amount of dog barking and stuff that would be going on, and the amount, the commotion and the traffic that would come into that area. I'm very familiar with this area, and there was some other special exceptions that actually I was against because of the traffic coming in and out of Marsh Road there, because there's been some deaths on Marsh Road there.
Mm-hmm.
And so there is a traffic that should be well made aware of that road there.
Well, I can tell you.
And going back to your variance there, this is an above ground pool. How
Yes.
difficult would it be able to move it out of that, in the event that were to go through? How difficult would it be able to move it into the setback?
The problem with that is that it is associated to the dock, which is in concrete pillars. So it has to be placed in relation to the dock where it is. So we would have to move the dock also. So we'd have to tear down the dock and pour new footers and everything else.
You've got 37 parking spaces. What would you do if you had an event just like you said, and you didn't expect the return out? How are you gonna regulate the turnout when you have more than 37 people show up for an event?
Well,
and I'm trying to figure out a way maybe to manage this, and an easy way to do that would probably be to make sure that folks RSVP ahead of time. And if you're not RSVP'd, it's one of those things where trying to control the management or even turn them away. I mean, if there's no parking, there's no parking, and that's one of those situations. And the only time this became an issue was I think the initial July event, with the expectations of the other aspects of what was being advertised. And these folks understood that that isn't something that we can do moving forward, and that we have to control this in a way that manages the size of it. That's the idea. And that from the August and September events, they were very low key. It wasn't nearly the same impacts that we're talking about from July, partly because the way that it was handled from a management perspective, understanding the issues from the first event, and trying to be responsive to the neighbors just from what they had heard. And I think that, you know, even a large number of these folks over here could probably attest to it better than I can because they were there physically. But, you know, if there's ways to manage it in a way that we're communicating with folks, communicating with neighbors, we're happy to do it. You know, I just, you know, I think it's always true that, you know, any event in itself, if, you know, doesn't have parking, you gotta move on. And if it has a limited number of parking, that's the rules they've got to abide by. But if there's a way to keep accountability and communicate, we're happy to do it.
Okay, the other thing here is you talk about working with local shelters. How does this go hand in hand with the diving?
That's just something we'd like to do, is help them. And it would not necessarily, what was discussed is possibly taking shelter dogs, bringing them out, see how they do with dock diving, what they think of it, what the dogs react like, and then promote that dog to dock diving people who might be interested in looking for a new dog.
Okay.
We wouldn't be housing them. We wouldn't be doing any of the actual adoption, anything like that. It would just basically be, okay, we found this adoptable dog that loves dock diving. Anybody interested?
Okay. All right, sir. That was all my questions. Miss Shelley, you had a question?
Can you turn your mic on, please?
This is a business, and all businesses, I have a business. You want your business to grow. And so, and the excitement, I mean, I have actually been, not here, but I have seen an event, and they are popular. And I don't understand how limiting to 35, I always get very concerned when the maintaining or the egregious, it falls on either neighbors to file complaints. It's a reactive enforcement, or you having someone at the gate that says, sorry, we only have, I'm just throwing out a number, 35 parking spaces, you can't come in. Those things cause tension, resentment, neighbors having to call in, and it's this self-policing that makes something very difficult. So that's just a comment out there.
Okay.
Well, as I mentioned, NADD limits the number of event or dives that the dogs can do during the day. And generally the dogs do several. Each dog will do several during the day, 3 or 4. So we're limited to 45. It's going to be really hard to get more than 30 people in there, 30 cars in there, if each dog is even doing 2 jumps.
I understand that.
So,
But
now
so
as
there are
far as
no, so
growth-
you won't have people coming in to watch? You don't have people watching the event? It's only the dog owner, only the dog?
Generally,
only-
it is mostly dog owners. There are a few spectators, but not.
But again,
more
it's
than a couple.
self-policing, so.
As far as growing the business, the growth of the pool would be that we're kind of limited on that because of the NADD and the area. If it ever got to a point where, okay, we want to grow, we'd probably move and
Well, and I think more importantly, you'd have to come back here and get a special exception approval. And just a few points maybe to help ease concerns here that, you know, we're happy, and I think it may have been a condition that, you know, if there isn't a complaint and it's verifiable that, you know, one of these conditions, a dozen conditions are violated, that, you know, these folks are happy to be held accountable as to the special exception. You know, it's something that, you know, gives teeth to what they're trying to do. The other side of this too is, you know, by right, there's, you know, ag businesses are allowed there. They're allowed to do outdoor events of 500 people. You know, there are things you're just allowed to do by right if you choose to. And that doesn't require special permission. It just requires come through with a site plan, show compliance with the code. The dogs, I understand, may be a unique factor here, but, controlling that aspect of it, again, with the NADD requirement for the splashes, the ways that we are committing to trying to limit the number, really puts them at risk. That if the special exception is violated, then boom, it's gone. You don't get to come back and try again. And that's the accountability that we're happy to do. And trying to ease concerns with impacts to neighbors. I think that shed is movable. Just thinking out loud, trying to work through things. That's something that would be a consideration because maybe there's a way to rework that. I really hesitate about the pool just because the footers are in the ground, and the permitting process for that was a little bit of a nightmare. But these folks want to do the right thing and make it right. But if there's, I'm just trying to think out loud because it's not unique necessarily to this business that some of the concerns we're talking about. But this business has a lot more accountability aspects to it with this approval than other businesses would have because they risk losing their special exception. The other folks don't. So it's just something to keep in mind.
Okay. I don't see any other questions for you, so we do have some public participation forms. I will allow you to come back.
Can we address this?
You sure can.
This picture is the perspective is a little off. That tent is actually right next to the pool, not next to the fence. That is our judge's tent that the judge that is judging the dogs jumping sits out there and watches the dogs. So it's actually a good 20 feet from the fence.
All right, it shows that your pool is 40-some feet away from the fence. That tent there
is a 10 by 10 fence.
Okay, is it right up against the pool? It doesn't look like it's
within 3 feet of the pool. It looks like it's right next to the fence, but it really isn't.
And I think the easy answer to address this is that if it's almost like a demarcation zone where we're not talking about structures or anything in there, it makes it very easy and easy to verify that if that's the way the special exception is conditioned, that judge's tent will have to just be relocated.
Yeah.
Which is something that these folks didn't realize at the get-go, that why we're here and why we're working through this, and to do the right thing, and that an easy picture can verify whether that's the case or not.
Well, now that he brings the picture up, I wasn't going to mention this, but you downplay the size of these events because of the amount of dives a dog can do, but yet looking at this picture, it looks like it was set up for a pretty large event, or that you were hoping it to be.
What do you mean?
Well, you've got the decorations up there on the top and everything. And I mean, for a few dogs, I don't think you would go all out like that in order to have just an event that you would hope.
Yeah, the sun sails on top. We pretty much leave them all the time for any of the use. It just keeps the sun off of the dock, so that it doesn't get so hot you can barely walk on it.
Okay.
That's not really decorations. It's not really decorations. And some of the things that you're seeing, like the banners along, are pretty much permanent. They're there too all the time.
Okay. All right. Like I said, we do have some public participation forms, and I'll give you an opportunity to come back and for rebuttal on these. And so let's get started with with Nathan Battles. Good morning, sir. Could I get your name and address for the record?
Absolutely. Nathan Andrew Battles, 3725 Marsh Road.
Okay.
I do live there, as well as own Noah's Ark Boarding Kennel.
Okay.
Me and my wife and children go to these types of events all over the country. My wife's the vice president of Gay Lake Dalmatians, actually based out of North Carolina there, but we actually hosted the Dalmatian Nationals last year, and maybe again this year. Now, it's not here in Marsh Road, but it's up in Georgia. I'm very familiar with these type of events. You cannot have more than what they state. I've been at them, fast cat, dock diving, all these barn hunt, all these different things for dogs. They have a limited amount by the AKC and these other organizations. You can't go past that. That's it. I volunteer my property down the road. If they have excess parking, they could park there and we could shuttle them over if that's a big concern. I don't have a problem with that. The car accidents on Marsh Road, let's be face it has to do with speeding and drunk driving. It does not have to do with people slowing down to go into a yard. I live there. I've lived there for a long time. I had a child run over by a car on Carter, which is real close to there. So that's a very big thing close to my heart that I don't want to cause car accidents. This is a misnomer. That does people, I was there during those events. I wasn't at their events, but I drove by multiple times. Yes, the first one had a lot of people coming in. After that, it wasn't. It was very controlled. And like I said, I very much volunteer my property right down the road. People can park there and they can shuttle over if that becomes a concern. Having this type of event coming to DeLand brings people in for local businesses, hotels, restaurants, going shopping, all these different things. It increases the local economy. On top of that, it brings people into DeLand. Isn't that what we want? And we want to have local businesses. To shut down a family trying to start, continue, and operate a local business, don't we want to improve our economy, not shrink it? The impact is positive, not negative. And yes, I don't live directly next to them. However, I think the neighbors being directly next to them have been lied to about the nature of what's going to be happening here. I think someone's been telling them one thing, and it's not what's actually happening. I live right down the road, maybe, a mile. I've seen the 3 events that happened there. I saw how they were run as I drove by. I participated in these events many times in supporting my dear wife because she likes these types of events. I would love for my kids to be able to just basically walk down the road and be able to do something like this. And I do own and operate a dog business real close to here. I understand the concerns. However, and you don't need a loudspeaker. They have boards. People go up, they see their name on a board where it's posted what time they do their jump and do things like that. You really don't need a loudspeaker. You truly don't. I've been to these events many, many, many times throughout the year. I'm welcome to any kind of questions anybody would have because I've witnessed these. I've been involved with them many, many, many times.
Okay. Okay, thank you, sir. Frederick Ford. Oh, okay. Did you want to speak again, sir?
Yes. My
Okay.
name's Frederick Ford. I live at 3098 Marsh Road. And what I mainly want to talk about is I've talked to the people. You asked about the adjacent properties. I have talked to at least one neighbor there and found out that there's some rumors and misinformation being spread. And I just wanted to straighten some of that out. We have covered part of it is that we are limited to 8 events, 9 events, according to what is on the recommendation there. We're not having them every weekend. It's been said that we were having them every weekend. We never were going to have them every weekend. We couldn't even handle it every weekend, to tell you the truth. The next thing is the loud music. We've covered that. We stopped that. Multiple food trucks coming in. We're not going to be having multiple food trucks. We had one. Now, if the county gives us permission to, we would like to have one, but we're not going to be having multiple ones, and it would only be for events, not at any other time. It's also the RV parking. We covered that we're not going to be doing that. The last thing is, again, the traffic. It's been brought up that there's a dangerous curve there, and even given examples of accidents that have taken out my fence and my neighbor's fence. Those did happen. They happened between the hours of 2 and 3 in the morning. You can probably guess what contributed to the accidents. They happened, 3 of them, between the year of 2000 and 2017. There was one other accident, and that happened at the beginning of 2024, I believe, or the end of 2023. A vehicle ran straight into an oak tree right out in front of the neighbor to the south of us property. He didn't slow down, he didn't swerve, didn't brake, nothing. I was outside when it happened and saw it. He went straight into the tree. He was obviously distracted by something. Don't know if it was his phone, whatever. Had nothing to do with other traffic. It had to do with him or her not paying attention. Those are the only accidents that have happened on that curve since we moved in 1993. So, and we really never wanted to have any issues with the neighbors or anything. We were trying to do things and wish we could have solved this without going through all this. Would have been better. Wish I had known about the special exemption required at the beginning.
Okay. Ms. Shelley, you had a question? Go ahead for the speaker.
Yes, clarification. On page 3, it mentions that events and competitions are held 9 times a year. Is that what you're planning to do?
Ma'am, you have to turn on your mic.
Sorry.
Yeah, we would be having probably 8 events throughout the year.
Throughout the year, okay. So it says it is.
One,
Go ahead.
one each month, generally through the spring, summer, early fall time. None during the winter.
Okay, but I was just
We
looking at
might
the.
have an additional, go from 8 to 9 if the weather is really nice a particular year that we can get an early one in.
Okay.
But the water's too cold, so we don't do the dogs during when the water's that cold.
Okay,
All right, sir.
thank you.
Thank you. Nathan Battles. Oh, you already
He
spoke.
already spoke.
You had 2 sheets here. Let me make sure I didn't put somebody else in there. Yeah, he had 2 sheets. Okay. Dwight Lewis. Good morning, sir. Could I get your name and address for the record?
Dwight Lewis, 860 Carter Road, DeLand. And I own the property to the south of this property. I'm adjacent to the dog park, or whatever you want to call it. You know, what's interesting to listen about all the corrections that are being made, and we're going to do this, and we'll do this, and we'll correct this, we'll correct that. To me, that tells you what they were doing that they shouldn't have been doing. Why would you be correcting something that you weren't doing? You were doing all those things. And I'm contiguous to the applicant's property on the south side. And I'm adamantly opposed to this special exception and variance to the minimum yard requirements. You will find in your packet letters from every contiguous property owner opposed to this special exception. The people that have signed those other letters do not live in close proximity. The one man that says he's down at the other end of Marsh Road is a long ways down there. He's not affected by it. I'm not against the dogs, and I'm not against, they trained service dogs. We trained service dogs for years while I was there. Never a problem. The problem came when they wanted to run a business out there, and they had all this people and those kind of things. And they're addressing problems that they created themselves. This area is residential, it's urban in design and development. You may have letters of support, but they don't come from residents out there. Their letters come from people that they do business with. And again, I want to tell you that I'm not against the dogs. I would go to a dog diving place, but I don't want it next to my house. You know, if they had, I'm not against the Speedway. I love the Speedway, but I don't want it next to my house. The problems come from the things that they've done in the past. One other thing, they were told to stop until they got a permit, and guess what? They didn't stop. They ran 2 more events after they were told you couldn't do them. So I'm not too sure that I believe they're going to change the stuff that they tell you they're going to change. Some of the requirements that you guys have put in there, I like them. They're good, and that's the right thing. I don't know if I like 9, maybe 4 events a year, and then enforce it. But I have a a tenant that lives in the house that I rent right next to it. My tenant is a Volusia County, it's funny, he's a canine deputy, and he works at night. He comes home 4 o'clock in the morning, and that's on the weekends too, and then he can't get his sleep, he can't sleep or anything. He's going to speak in a minute. You can ask him any questions about that. They advertised one time, bring generators and stay. Again, we're going back to stuff that they were doing, not what they've said they will do. That's a different story. There may not be some of these things in here if they hadn't already done them. They've already done these things. And I would ask you, would you like this next to your house? I doubt it. What's that picture? When they were training service dogs, we liked that. I tried to keep the fence clean down in between the 2 properties, keep it mowed so that when they were training and out there, that they weren't distracted. And they've been pretty good neighbors. It's just, I don't like what's going on here. Thank you.
Thank you. Mr. Brett Winston?
Good morning. My name is Brett Whitson. I live at 3030 Marsh Road. I live at the property that shares a property line with 3098 Marsh Road, which is the property in question here today. Going through, I've made a couple bullet points I want to talk about. Council said the outdoor event for A1 property is a right, but it also has some stipulations as far as the noise and the level in which it disrupts public morals, where there's sound and there's noise complaints and such. That's certainly the case here. The folks there have been instructed to stop holding these events, and in fact that they continue, and you heard here today that they said that they couldn't or they wouldn't. They chose not to. It's not that they couldn't, they chose not to. So the enforcement that Mr. Mills brought up is definitely an issue, because here they were told cease and desist, and they said, no, we're going to continue. In the immediate area, council said there's been letters from folks that live in the immediate area. The immediate area is defined as someone that lives directly surrounding a specific point. You won't find that. What you'll find with the immediate area is people that are opposed to this. Initially, they did invite overnight camping, plenty of room for RVs, bring your generator. I don't think that's happened at the other 2 events, but that was advertised initially. It said 8 or 9 events, and then it was brought up, how is that going to be policed? These are often on weekends. And when I've called to make complaints, I'm sorry, there wasn't anybody to do that. The sheriff's office isn't responsible for code violations, so they won't send somebody out for that. And they also say 8 or 9 events, but what that is that's a weekend. But leading up to those 8 or 9 events, they have practice, they have training. So that place is packed leading up to an event, not just on the Friday, Saturday, Sunday of the event, but of the days coming to the event. So they're hosting people out there. They advertise on a Facebook page, pool rentals, and it's hourly, however the case may go. So yeah, they may want to have 8 or 9 events, but how many days leading up to those events are we going to have this? Mr. Battles, he says that he wasn't there, but he spoke on how well it was controlled. Neighbors have been lied to. They've seen it firsthand. So the neighbors see it. They weren't lied to. This is the neighbors' opinions. And then those opposition letters, that's not something they've been force-fed. That's something that they chose to complete and to send in. In accidents, Mr. Ford mentioned vehicle accidents. I don't believe that any event there contributed to any accident. But he mentioned that it was from a distracted driver. Would these events not certainly bring a distraction to motorists passing by? I think it would. So I work at night, and I just ask that, although yes, I chose to rent, that doesn't mean that I'm not entitled to peace and quiet in my home. When I get off work, my children, who are both homeschooled, have IEPs. They are distracted by this. They have to wear headphones during the day. I have video sound bites showing their property from my front porch that I can play, and that's from the August event. So, this is from my front porch, and I can show each member the video it shows facing directly towards them.
All right, sir, your time's up. I'm sorry that, but your time's up, so we're going to have to move on to the next speaker. Okay?
I understand that, and I appreciate that. Thank you.
Thank you. Okay. Mr. Christopher Hutchie? Apologize for butchering your name, but I'm going to ask you to say it again now anyway.
First name's Christopher, last name's Hutchko. My address is 14841 Northwest 66th Avenue in Chiefland, which is about 2.5 hours from here. I am the owner of Trax Canine Club, which is a dock diving facility. I dive in 3 different organizations. I'm probably one of the largest dock diving facilities on the East Coast. I've been to this facility twice. Actually, for his video, that was one dog probably waiting to go up on the dock to jump in a pool of water. They get really excited when they jump up. Our facility, the amount of dogs that come to our facility is the people in the area. We rarely have people from outside the area come. If we do, it's 1 or 2 dogs that come from maybe a Georgia dog or someone's traveling through the area. We've been in existence for 4 years now. I'm also part of Central Florida Search and Rescue. I work with Volusia County. We do human remains detection and live tracking. So I'm in this area a lot. So I've actually known these guys for 5 years once I started dock diving a long time ago with just 1 dog. Now I've grown into my own facility. I live in almost the same kind of area they do. I have average of 30 dogs, 40 dogs that come to my events, and I've been operating for 4 years now. Their facility, the twice that times that I've been to it, there's 15, 20 dogs. Because the dogs come, they jump in the morning, they leave. Oh, I'm sorry. They jump and they leave. The same when I was there. Their last 2 events that they said that people were saying that they ran their events, I was signed up for them. Both events have been canceled, and I didn't go. So I don't know where that came from. From what I understood, they complied with not having their events there. Any questions that you want from me? Because I own the same exact type of facility. Our facilities are almost identical in the rural area that I live in. So I just feel like I had to come here to just, if there was any questions on how, what goes on at these events and like the noise or PA systems. We don't run PA systems at ours. We don't run music at ours. There's a huge board where the people come in, they put their names on, they know the order. Most of the people are it would be like just in this room right here. They all know each other. They all know each other's dogs. If I say my dog Mazakine, that's my dog. If she's up next, I know on the list, I know everybody else's dogs in here and when they're up. So I know to get my dog up and get them ready to go. And they're literally jumping into water. Dogs are having fun jumping into a pool of water. It's not an elaborate thing. The ESPN isn't there. It's not, it's just dogs having fun. I am a trainer. And when you consider dock diving training, it's teaching dogs to swim in a pool. It's teaching them to jump off a 2-foot-high dock into a pool. So it's not extensive training. Now, when I train search and rescue, I do human remains. That's a whole different story. It's just, but as far as dock diving, it's fun for dogs.
Okay. Well, your time's up, sir. So thanks for your information.
Thank you. You're welcome. Appreciate it.
All right, Samantha Pasco. Good morning. Could I get your name and address for the record?
Samantha Pasco, 3311 Kumquat Drive, Edgewater, Florida. I have known Val and Fred for a very long time, back to my college years, over 10 years ago. So, first off, I want to say I am one of the owners of Superior Canine Academy, one of the only dog training companies that work with some of the most aggressive and anxiety-ridden cases in the general Volusia County area. And this outlet, this type of activity is crucial for these types of dogs to build confidence. They get to bond with their owners on a completely different level than they can at home in a general day-to-day life. And I find that dog sports in general are being misrepresented. A lot of people in the general public do not understand what dog sports do for dogs. It builds an enormous amount of confidence for these types of animals that are struggling at home in their normal day-to-day life. So dock diving in general is not just a fun, my dog goes and jumps in the pool. This is huge for dog behavioral issues. This is huge for clients to be able to learn how to handle their dogs. And I find that this is not being represented, appropriately. It's not a free-for-all. Dogs are not out there running around. Dogs are not loose. Dogs are not having, a complete uncontrolled experience. Dogs are out there learning. They're building confidence. They're spending time with their owners. They're spending time with their friends. And this type of facility is very much so needed in this area. There's nothing like this in this area. So just wanted to put my opinion out there because I do think it's being misrepresented. This is huge. Thank you.
Thank you. Okay, Mr. Roland Simon.
How you doing?
Good morning, sir. Could I get your name and address for the record?
Roland Simon, 3200 Marsh Road. I'm adjacent north of this property.
Yes, sir.
A lot of comments here. I've never heard anybody say anything about property value. Is my big deal with him was property value. I mean, my wife moved here in 2011, and we love the area. We love the neighbors. We really haven't had any issues with the neighbors at all. But this particular thing has just brought a lot more traffic. My wife says it's just, she's scared that it's going to blow up a little bigger than it's been. And we don't mind. We love dogs and we love animals, but we just don't think this is right in this area. We think it could be somewhere else where there's a lot more room and not homes next door. I mean, I understand the neighbor that he works late and he should be getting to sleep. So, yeah, we're just concerned more about the property value and the traffic, and hope they can, resolve whatever they need to get done.
Okay, thank you, sir.
All right, thank you.
Okay, that ends the public participation. I'll let Mr. Posey come back and give a rebuttal.
Again, Joey Posey, 420 South Nova. Just to touch on some of the things I heard, in terms of the nature of how we got here. We were very transparent about the initial July meeting. Code enforcement moved very quickly to cite them and get them on an agenda, and we had a hearing in October. And by that time, the August and September meetings or events had been committed to, and people were there. They were intended to be there. But we told staff, we told everybody that, guys, as much as we want to unwind it, there's a lot of commitments to folks that had to be there that it would have been very difficult, and it would have risked the certification with the NADD. But we made the commitment after that to say nothing. I mean, that is what has happened since October. That nothing moving forward from then. We've been very clear about that representation. The other parts to this, in terms of the property values, and again, it's one of those things where I really just feel like this is one of those little niche uses that can really be an asset to folks, and it doesn't have to be a very large or a very big enterprise, and that's the whole reason for conditioning the special exception in the way you can condition it, and if in terms of impacts, if there's a way to manage and even more than is already being managed. Moving forward, they've been trying to do it the right way from those August, those September events, and that would be the norm moving forward. And again, just trying to figure out a path forward for these folks. If the buffer is the issue, we're happy to do a buffer. If it's the shed, that it is movable, and that'd be easy. That'd be an easy relocation, and you're really just drilling to feel out how to be a good neighbor. That's the whole goal here, because I don't want the neighbors fighting either, as much as I can feel the tension that's happening over here. So I'm open to suggestions. I really just feel like in terms of what these folks have a right to do on their property, this isn't much of a pivot, other than that it just happens to have some of the dogs associated with it, and that's just something that I hope folks realize when we're talking about how to do this the right way, that everybody has a right to utilize their property, utilize it under their existing zoning, and within that context, how do we make this the least impactful? That's the goal I'm trying to reach. So I'm open to suggestions and questions or anything that we can do maybe to clarify. You know, this group over here is actually the group in support, and I know some of them are shy, but you know, we're trying to do this the right way for the community.
Hey, Mr. Costa, you had a question?
Yeah, you actually have probably more than one, but we'll start with the first one.
Yeah.
Because I know you read these documents diligently. And so on the very first one, the 25001, the special exception itself, did you dive into why staff recommended denial if this, in fact, as you say, is basically a slam dunk?
Well, the staff report from and I don't want to necessarily speak for staff, but the way I interpreted it is the nature of the three adjoining owners in their opposition, and the fact it didn't meet the buffers, and that was essentially the reason for the denial. In terms of meeting the literal code requirements for a special exception, this special exception, it meets them other than the buffer.
Absolutely. You're making that as an absolute statement.
Yes.
Okay.
And correct me if I'm wrong. Is that a fair characterization?
If you approve the variance, they can meet the setback requirements. What they fail to meet is the compatibility with the neighborhood.
Gotcha. Yeah. Okay. And then my last one is, as you see, we are a limited staff up here, limited group. And I know you can read a room pretty well. So just proceed with caution from there.
Is that it, Mr. Costa?
That's it.
Okay. All right. I did receive another public participation form, but we'd already closed the floor for that part of the meeting. It's in favor of the request. Do I need to listen to their? I'll ask you. I mean,
I'm not sure who
Does any of the board members want to open it back up?
I think that if we have an extra one, I think we should go ahead and listen to it. This is contentious case right here.
Okay. Everybody agree? Okay. All right, Mr. Brian Fiddler.
Hi. Good morning. My name is Brian Fiddler, owner-operator of Superior Canine Academy with Samantha Pasco, 3311 Kumquat Drive. I did just want to clarify some things. I'm not up here to give any kind of, I think people have done a great job giving their emotional arguments for things and everything. I did want to clarify some things with people announcing with barking dogs and kind of the idea that it's been mentioned that I have a dog park next to my house. I understand that the typical public understanding of dogs is mostly dog parks, boarding facilities, things like that, very uncontrolled environments with dogs. This is not actually what that is. This is not, and I will say at the events on that property line, I would probably say there's rarely any dogs actually by the property line. What you would be looking at is majority of the dogs are kept in kennels inside of the owner's cars on the other side of the dock in the parking area. And they're very controlled. Most people do not put up with barking behavior from their dogs. Yes, you might have a dog or two that are on the dock that are barking at times and things like that. But I could see where you could make stipulations where only you could have, you know, the dog on the dock, a dog in the hole waiting to go on the dock, and then all of the dogs also put up to where they are controlled and not out. It's not a free-for-all. There's not dogs off leash running around playing. It is not a dog park. These are people that I would say majority of them agree that actually dog parks and dog boarding facilities are actually detrimental to dogs' health, and they do not actually do a lot of dog social interaction that you guys would probably recognize from the public view. So I do understand that there are some differences here, and it is hard for you guys to picture this, but this is not just a wild free-for-all where dogs are out running around, causing havoc, dogs at large, those kinds of things going on. And I just feel like that hasn't been described very well to everybody here. So I also train dogs. I do compete. But I did want to kind of clarify that for you guys, that this is not just probably what you guys typically see, and it would be very beneficial if people from this board or anything would come out to actually watch an event to see how controlled the environment actually is. There's not 40 dogs along the property line that are all barking, playing with each other, running around. Most people have their tents set up behind their cars. They're hanging out. These are also events that are very family and social friendly. They are not usually, there's no alcohol at these events. This is not an event where people go out and are partying and there's a lot of loud music and stuff. People are literally there to get their dogs some exercise, to play with them, to get them an outlet, and then go home. This is not something where it's like a huge social gathering where everybody's hanging out with each other. Everybody usually has their dogs put up for the most part, unless they're walking to take their dog to the dock or go to the bathroom, things like that. So I just wanted to clarify that for you guys, for people who probably have not seen these events before and seen these things that are going on.
Okay. All right, thank you.
Yep.
1 second. Again, Joey Posey, 420 South Nova. I was talking with my client, and some of the things we heard tonight or today, that if there's ways to mitigate it, if there's ways to handle this, we'd love to continue that outreach and honestly meet with the neighbors. So my recommendation to them, and they would be willing to do this, is that if we could have 30 days to have that discussion, an open invitation to anybody that has concerns, sit down and talk about this and find ways to address concerns that may be perceived and some of them that may be actual. I recognize that, that I would at least ask for 30 days to continue it to the next meeting, to have those discussions with the folks that I've heard today and, continue the dialogue and be good neighbors. That's really what the goal is. So if that's something you'd be willing to entertain.
One of the things I wanted to ask you, I'm glad you came back up, is the cease and desist. Were there any events after that order was?
After the initial notice, that's correct, because what happened after the July event, the notice went out for cease and desist towards the middle to end of July. I have the dates in the presentation, but the August and September events had already been committed to. There were still scheduled events for the rest of the year, but the August and September ones already had commitments to actually run the event. They couldn't cancel them. But we made that very clear right after the notice to staff, to code compliance, that those are the two that I can't control. I can control the rest. And I've probably had that conversation several dozen times to reiterate it, but I'm here again just to say that we've been transparent with trying to make sure that they understand that I just didn't have control over those two events, but every event since October has been canceled, moving forward. There's been no activity for the dog diving special exception.
Okay. All right, sir. Mr. Costa, you had a question?
Yeah, well, a couple things. It would be nice to, as the last speaker said, to actually go and witness an event. Unfortunately, you guys are in a cease and desist mode, so we can't do that.
We offered, but nobody took us up.
Well, it was before it came before us, but I don't remember getting that offer personally. So because I would have attended something like this to find out what we're dealing with here. As far as the continuance is concerned, I would say that your best course of action would be to sit down with the neighbors and hopefully come up with a reasonable compromise, if you will. This reminds me of the reason that I'm sitting here at this chair was a similar exception, and it had to do with the borrow pit. And I got involved with that as a resident at the time, and we were able to come to a consensus with, again, you have property rights. And as you stated on your very first slide, so I look at that, but it's a matter of harmony in the neighborhood, right. And hopefully you can come to some kind of an agreement. I personally would support a 30-day continuance on this one, so we'll go from there.
Okay, Mr. Soria.
Yes, I've spoken with Ms. Smith. We would recommend, due to the nature of this, to continue this to the May 15th. That gives them time to schedule a meeting, get input, and gives staff time to collect all that information and write the report. I'm not sure 30 days is sufficient to cover all of that, considering all the issues that need to be discussed and ironed out.
Okay. We have no objection on our end.
Okay.
Need a motion on that?
Well, as far as the continuance, we are doing a recommendation. It's not a ironclad decision.
You have the variance attached to it.
Pardon me?
Variance
attached
is
to it. That
also-
is
Yeah, I know the variance, yeah. Okay. Well, the variance is looked at as far as a variance. I mean, the variance could be, it's null and void if this doesn't go through. Is that correct?
The special exception is contingent on the variance because they need to meet all the criteria. So they're kind of tied together. So if you approve the special exception, hopefully you'll approve the variance. Because otherwise, if you deny the variance, the special exception kind of fails. And if you approve the variance, it's presumed you're going to approve the special exception. So they are slightly tied together.
If I may, are we suggesting then that we continue both these cases?
Yes.
Okay. All right. That's what I was hoping that was the case, that not one, I would continue both simultaneously.
Well, if you'd like to make a motion, I'll go ahead and accept the motion,
Okay.
and then what we'll do is discuss the motion, and then we'll move forward.
In that case, I'll make a motion on case S-25-001 and case V-25-023 that we continue both cases to the May 15th PLDRC meeting.
I'll
Okay.
second that one.
Okay, I've got a motion on the floor to continue case S-25001 and V-25023 to our next May 15th PLDRC meeting. From Mr. Costa and a second from Mr. Sixma. Any discussion on the motion? There again, I will say that this would be a, as far as forwarding for the special exception, it is a recommendation. And council's still going to hear this. It's not like it's an end-all here.
Mhm.
We've heard the entire case, and I don't know how the people that come in would come back. But if it's the commission's desire to continue it, then I'll go along with it.
Well, Mr. Chair, my comment would be that it doesn't sound to me like the applicant and the neighbors have actually had a sit-down conversation as to try to iron out some of the kinks and opposition of the neighbors have. They may not change their mind. You're absolutely right, but I think the opportunity to give them to sit down with those three individual neighbors and see if there's a compromise that can be reached that would make everybody at least satisfied with the scenario, I think that's worth a continuance.
All right, and saying that would be the only way I would ever give my approval is if something could be worked out with adjacent property owners.
Mhm.
So, Ms. Craig?
There was some discussion about the food trucks being specifically denied and also signage on the road to try to alleviate traffic issues. Should those be made part of staff recommendation?
Ms. Smith, could
We can add those to the
we can add
revised
those.
staff report.
So you'll have to address those too, Mr. Posey. Okay. All right, I've got a motion on the floor and a second, and we've already discussed it. Any other discussion on that motion? All those in favor, say aye.
Aye.
Any opposed? Motion carries unanimously.
And it's
So
May
we'll hear
15th?
this case again on May 15th for those of you that are here today, and we'll go from there. Miss Shelley, could I get the next case, please?
Yes, sir. Case number S25-006, a special exception for communication tower exceeding 70 feet in height on prime agriculture A1 zoned property.
Thank you, Miss Shelley. This is Miss Reyes. If I could ask you to take your discussions outside the dais, please. We'll wait for it to clear out a little bit. Okay. Miss Ray, this one's yours.
Yes. So the applicant is requesting a special exception for a 195-foot monopole communication tower on a 4.84 acre parcel. The parcel is surrounded by agricultural properties and single-family residence to the west and south. It is approximately 334 feet west of the Turnbull Hammock Conservation Area. The property is heavily treed and The current use is a dairy and feed lot. The proposed lease area is 10,000 square feet, located on the eastern portion of the property. It is proposed to accommodate up to 4 tenants, with Dish Wireless being the initial leasee. It is proposed to have a galvanized gray color, and it will have a 30-foot ingress-egress and utility easement from Volco Road. The tower will close the coverage gap between 3 towers, with the closest tower being approximately 2.7 miles to the northeast. The project is not likely to create undue traffic congestion, as the site will be visited for maintenance only. It is also unlikely to be a hazard, as the fall radius is approximately 95 feet, so if the tower were to fall, it would remain on the parcel. We did receive a letter from the Federal Aviation Administration stating that the proposed tower will not be a hazard to the air navigation. Staff's recommendation is to forward to County Council for final action with a recommendation of approval, subject to 5 staff conditions. I do also want to note that we did get a letter of opposition from the adjacent property to the north. I'm available for questions.
Thank you, Ms. Ray. I do have a question. Are there any other towers in the area that we may have overlapping coverage?
Yes, sir. So there are 3. However, they are quite a distance away. The closest is about 2.7 miles to the northeast. And so this proposed tower is to close the coverage gap between those 3 towers. We do also have the applicant here so that he might be able to elaborate more on that.
Okay, and do we know the distance the distance of these towers that are, even though they're 2.7 miles, is there any overlapping coverage?
So within the packet, there are propagation maps, and it does show. Yolanda, are you able to pull?
It's on page 42 and 43. So 42 is without, and 43 is with for the propagation maps.
Okay. Coverage without, coverage with. Okay. That's all the questions I have. Okay. Is the applicant present?
I'm sorry, where's the location of the tower on these maps?
Maybe we can ask the applicant.
I am, Mr. Chairman. Jonathan Yates, 105 Broad Street, Charleston, South Carolina. First and foremost, I want to thank Ms. Kristen and Ms. Yolanda. During this process, I asked 101 stupid questions. They never laughed at me. Their professionalism, courtesy is well respected. This is a piece of property owned by Ms. Kim Payne. She unfortunately couldn't be with us here today. It's about 5 acres, and she bought it about 20 years ago. It used to be used for citrus farming, like a lot of that area. And presently, just a lot of trees on the property, no structures on the property. The purpose of the facility, we not only have Dish Wireless, also Verizon Wireless. They're trying to cover what we call a donut hole or a deficit area. So you have above us, a Crown Castle Tower. It's about 2.7 miles away in the north. You have an American Tower about 3.6 miles to the south.
I want to interrupt you. On this map here, can you pinpoint where tower will be? Just so while you're talking, we'll get a general idea of what you're talking here.
Where it says, so there's kind of a hole, the light green.
It should be.
It's right in the middle, where it says 630A. That's where the proposed site is.
Right there.
Yeah.
Right there?
Yeah.
Yes.
And this is Jessica Ross of TowerCom, my colleague.
That's the one that's 2.7 miles away?
That would be the 2.7 is to the northeast, And then you have about 3.6 to the southeast, roughly.
Mr.
Okay,
Chair,
in
what's,
relationship to where this, what she referenced there, the 60A, where is the tower that you're proposing?
That,
She said
that's it.
Oh, that is it.
That
Where
is-
the,
yeah,
where the hole is.
Got it, okay.
that is it.
so this is the before map, and
Mhm.
Lon, if you can scroll down, this is the after map.
Got it. Okay.
So you can probably switch between those two to discuss propagation.
Okay. Proceed with your presentation. I'm sorry to follow along with you. Me personally, I needed to see where this tower was going.
Absolutely. And that's the true purpose of the facility. We have a deficit there. Verizon has a deficit. The other carriers have slight deficits there. The facility has been designed for Dish, Verizon, and at least 2 additional broadband carriers. About the facility itself is a 195-foot monopole, 4-foot lightning rod, and that's essential as brought up by staff. We have been reviewed and approved by the FAA, and most importantly, they also found we're about 4.5 miles from the Massey Ranch airstrip to the north, so we will not have illumination. This tower does not have to have the air nav lights on it. I know we got some folks here that want to talk about it, and what we want to stress to the neighbors is this will not have lights. If this board recommends approval to county council, if county council is willing to approve it, it takes about 30 to 60 days to put it up. Most of that's in setting the foundation. The tower itself is stacked in a day, so we'll have a little bit of traffic on Valco Road during that period. After that, the carriers only come about 8 to 10 times a year, so we're not creating additional traffic on Valco Road. The equipment is monitored and for the most part operated remotely. The facility does not put out any noise, odor, lights, vibration, fumes, or glare. What it does, it improves wireless voice, broadband in the area, and most importantly to me, access to 911 first responders. You have in Volusia County the Alert Volusia Emergency Notification System. It works a lot better if you can actually get the notifications out to people. We spent a lot of time working on this, working with Kim to make sure we had the best location on the property, wanted to have adequate setbacks all the way around to adjoining properties. A couple other things, this has been, the pole has been reviewed and designed by Florida professional engineer Robert Beacom. He's designed it to the ANSI TIA 222H standard of 140 mile-per-hour winds. Living on the coast, that's important. I hope we don't get a blow in the fall. But we've over-designed it. In addition, Mr. Beacom has designed it with a 95-foot fall zone, so the fall, if in a catastrophic event, would be all contained within Ms. Payne's property. So again, what we're trying to do today, some people call us the fourth utility. We're called wireless infrastructure. For a lot of folks, we're pretty important. We want their phones to work, whatever they're doing on the phones. You know, whether they're accessing the internet, trying to get 911, we want their phones to work. And that's what we're trying to do today, is cover that hole. We have a little bit of a donut hole. You have a little gap between the other towers. This is designed to do it. Again, initially Dish, Verizon also, but we provided space for the other 2 broadband carriers as well. I'm here for any and all questions.
Okay, Mr. Costa, you had a question?
Yes. How is this being powered? Electricity-wise, is it?
Yeah, we have a 30-foot access utility easement coming in from Valco Road. We're coming in about 115 feet.
So you're tapping into FPL
Yes,
to
sir.
power this?
Yes, sir.
What about backup generator?
That is up to the carrier. Verizon typically does. Does Dish go with a backup? Yeah. Dish does not have one proposed, but Verizon particularly does have a backup generator.
So there'll be a backup generator at the site as well?
Yes, sir.
Okay. Obviously, that exercises periodically, so you will have a noise generator. And obviously, during any kind of power outage, it will also be operating as well to keep the tower running. Is that correct?
Exactly.
Okay.
Exactly. And we would do testing. We require our tenants to only do testing between 9 and 5, Monday through Friday.
Mhm.
No testing of the generator on the weekend. And obviously, if that generator is running after a natural event, there'll be a lot of other generators in there.
Sure,
running
absolutely.
as well. Yes,
Okay.
sir.
All right, thank you.
Thank you, Mr. Costa.
Okay, and also, I wanted to address one thing here that we had on a letter of opposition.
Yes, sir.
EMF exposure. I don't think any of us are very much.
Mr. Chair, I'm going to stop that discussion. You cannot consider that information. Telecommunications Act is very specific that you cannot render a decision on the basis on the environmental effects of radio frequency transmissions, which includes EMF exposure.
Okay, that's the end of that then.
Thank you, sir.
Okay. All right, we do have some public participation forms. I'll give you a chance for rebuttal after we've heard their discussion.
Yeah, and we're looking forward to hearing the discussion, so hopefully we can work with these folks and answer their questions.
All
Maybe
right,
not.
sir.
Thank you, sir.
Okay. All right, we're going to get started with, Matthew Victorelli. Good morning, sir. I hope I didn't chop it up too bad. And your name and address?
My name is Matt Victorelli, and I own the property across from them. It's 89 lot, and it's a vacant piece of property right now, but I plan on building a house there someday. And I'm concerned about the EMIs, you know, the radiation that comes off of it. We've had it for 2 years now, and we camp out there, and we use it just for a recreational area. I'm concerned about the generator making a noise. It's nice to camp in quiet and peace. It's an eyesore. It's a depreciation of our value of our property. And if anything, change carriers, you know, get T-Mobile. Ours works fine. Everybody in the area doesn't have a problem with it. And that's all I have to say.
All right. Thank you, sir.
Thank you.
Greg Petrzak? Petzak. It's pronounced the way it's written. I just tried to put a little extra
Make it
in
fancy.
Good morning, sir. Can I get your name and address for the record?
Sure, Greg Petzak. I live at 4721 Lingo Grove Road. My property's mostly on Lingo, and it adjoins the Volco area there. And I'm on T-Mobile, okay? I got perfect service out there. I don't lose signals at all. I mean, we do at times during a hurricane, you know, when the towers go out for a day, but our phones automatically go into satellite mode with the Starlink. So what I'm looking at is you know, the cell towers are going to be a dinosaur in the past, okay? Because you look every 2 days, Starlink's going up with satellites, right? That's what they're going to do. It's going to go all satellite phone. So when this thing, after a few years, everything went satellite, and we're looking, you know, with the cell towers are going to be a thing of the past. The thing's going to be out there. It's going to be an eyesore. You know, decreases our property value. 10%. And a couple of the houses around there. Plus, I'm within the range there, and I'm worried about this RF factor going on, and when it's transmitting. And plus, I'm a pilot, and I do fly a helicopter, and I do land out back on my property with it. So now I have a navigation thing. If this thing's not going to have lights on it, I'm going to be landing out on my property. And I do have a couple other aircraft that come out there every now and then. And Volco Road, if you don't know it, it's a dirt road, and it is very highly used during the day. So, I mean, I'm totally against this. I don't want this thing in my backyard.
All right, sir.
All right, thank you.
Robert Brown. Good morning, sir. Name and address for the record.
Robert Brown, 2695 Volca Road, immediately west of this particular property.
Okay.
And this cell tower is going to be 400 feet from my house. I have horses. I got studies from 38 countries.
We can't discuss that. The
He
attorney
just said you
he
can't use
could.
that. Okay. It decreases our property value. It's an eyesore. We live in the country. We have perfect phone service. All of us do. None of us in that area have any problem with cell service. There's a tower, he said, to the northeast. It's to the northwest. And there's another one south. There's maybe, like you said, a donut hole is about what it equates to. If there's any, I can talk on the phone from one end of Volco to the other. I've been there 10 years. My horses don't like any of that type of frequency. And my neighbor who had to leave has 37 acres directly behind her to the north, and he breeds cattle. And we just seen this pose as a threat to our livestock and property value and our own health. So I know you're not allowed to talk about the health thing, which I completely don't understand that, but I have studies from 38 different countries that say different. And that's pretty much all I have to say.
All right. Thank you, sir. Mike Bennett. Good morning, sir. Could I get your name and address for the record?
It's Mike Bennett, 2625 Volco Road, and I'm only about, at most, 300 foot from this thing. Now, I don't have a house there yet, but I bought the property to put a house on it. There's no issues with that kind of thing at the present moment. So, what's that going to do for my property when this thing's sticking up there? And RF waves are a factor. I don't care what anybody says about that. So, I mean, it's going to be detrimental. I'm going to have to either sell that land and get whatever you can out of it. We have good cell service there. I don't understand what they're talking about, a donut hole. So, yeah, I don't see the need for this thing to be there. And there's other places that would have less impact on people that live in that area, because there's plenty of open area around there. I mean, that's 300 foot is not, that's at the least is 300 feet. So I apologize for
No, you're fine.
that.
You did very well.
It's nonsense is what it is.
Okay.
So, because we all have good cell service. If you want to come out and check it, you can clearly see that we don't have an issue there. So, thank you very much.
Thank you, sir. And that ends our public participation. Can I get the attorney to come back up for rebuttal or explanation?
Chairman. And we're going to talk to these folks afterwards, see if we can address their concerns other than discussing the health. Whenever you do a cell tower, you always have neighbors. And why is that? We have to put them where people are, where people live, where people travel. It's all part of a network. If you drive throughout Volusia County, there's cell towers throughout the county. Some of them are right next to where people live, others in commercial areas, but it all works so everyone can use their phone at all times. That's the purpose of a network. I think if you look at the tower ordinance and the criteria for special exception, my opinion is, it'll be your opinion that counts, but my opinion is we met the requirements. We have a 5-acre parcel. We are doing a 195-foot monopole tower. It has been approved by the FAA. 2 carriers right now say they have a need. And they have a need. Verizon and Dish, they don't put equipment on a tower unless they need to. There's 2 types of needs. There's coverage, base coverage, and capacity. As more people use a tower, you have to split the cell and have more cells. This is needed. This is needed. We will work with the folks around, see if we can answer their questions. But we feel if you look at Kim Payne's property, Kim's owned this property for 20 years. I feel that Kim deserves this in that I feel we met the requirements. We cannot always make everyone happy. We're going to try to. We're going to try hard to work with these folks. But just looking at it, looking at the staff recommendation, did we meet the ordinance? I feel we did, but that's your decision.
Thank you, sir. Mr. Costa, you had a question?
Yes, I do. Could you put page 11 back up? You had it up there briefly. I thought you were reading my mind. Page 11, yes. Just to clarify a point, because we've had two of the public participants that came up, both stated numbers, feet from the tower, and I want to take a look at that page real quick. Just confirm with you that what I'm seeing is correct. So if I'm looking at this right, you've got the setback to the closest barn is 600 feet.
Yes, sir.
And the setback to the closest house is 748 feet.
Yes, sir.
Not 300 or 200 foot like I heard before.
No.
Okay. There's not, because the rest of it's vacant land to the I guess what, to the south side of that property. That's
Yes,
all
sir.
vacant. So the only structure is to the north end.
Yes.
Is that right?
And we're going to talk with Mr. Brown.
Okay.
He is the closest.
Yep.
His residence is 748.
Yep.
His barn is 600. Kim had talked to him a while back, but obviously we need to talk again.
Mm-hmm.
Kim wants to be a good neighbor.
I would suggest it, yes.
Yes, sir.
I think if you take the proper steps and get with the neighbors and put their concerns at ease regarding the RF and EMF, obviously we can't discuss that at all. That's a different ballgame there. I know that I do have one within 300 feet of my property, and actually I don't even know that it's there most of the time, other than the blinking light that this one is lit. It does have a red beacon on it that comes on from time to time, but
That's
short
what
of
we
that-
found, Mr. Costa.
I'm sorry?
We found, Mr. Costa, there's a lot of outcry at the start,
Mm-hmm.
but then some people call and tell us, when's that tower going up? And we go,
Yeah.
it was up a year ago.
Mm-hmm.
It's sort of like when you're driving home.
Yeah.
There are power poles and telephone poles the whole way. You don't see them. They're there, but you don't see them. And particularly with this, without the air nav lights, you're not going to see it at night.
Understood. Thank you.
Thank you, Mr. Costa.
Okay, that ends our, do we have any more public participation forums? We don't, right?
No, sir.
Okay. I'm going to close the floor for public participation, open up for commission discussion or motion, but first of all, I'd like to ask, let me see, who's this? Miss Ray, and I guess I could ask Miss Smith too, this question. A comment was brought, it kind of rang a bell here, was brought up about Starlink. We know that's part of the future. Is that ever in consideration with some of these towers as far as approving or a recommendation of approval?
I can kind of answer that. So, a lot of the hype on what we call small cell towers, kind of overblown. They are prevalent in dense urban areas because of the way the technology works. It's very short range. It still needs what these legacy towers to kind of operate. Starlink is a different because it's works on a different system, but my understanding is kind of the backbone of telecommunications is still based off of these legacy towers, and only when you get to the dense areas are when you get the kind of the small cell towers that are basically, they look like light poles or they're attached to light poles.
Mm-hmm. So in other words, you would still have a connection with the Starlink with the larger towers. Is that what you're telling me?
I think Starlink operates independently. That's another type of service and another type of process than the frequency allocation issued by the FCC for the traditional communications, like your 4G and your 5G and your 3G technologies, operate off of the FCC's allocated frequencies. I don't know that Starlink does. I think Starlink just shoots through satellites.
Okay. Well, the reason I was even brought this up, I don't want to approve a steam engine when I got a brand new diesel fixing to come hit the lot. You know?
I think these are for mobile tech. I believe Starlink. You need a device, so that replaces your broadband. It replaces your physical wired connections. It does not replace your cellular service.
Okay. That was my question, and I'll entertain a motion. Ms. Shelley, go ahead. Yeah, I already closed the floor.
Yeah.
Ms. Shelley?
Yes, on the staff recommendations, I just have a question about the requirement, it states in here, for the tower to be no less than 1,000 feet from residential structures is waived. And in this case, it sounds like it's close to residential structures, 400 feet, 300 feet. Why is that considered that's waivable? 738,
Because
okay.
the code is written in such a way as to waive that provision. I believe this goes back, but towers used to not be designed to collapse in on itself. So you would have a massive fall zone.
As opposed to
right.
what
So
they
this
are now.
tower, in fact, some towers supposedly have a 0 foot, like they're engineered in such a way as to collapse on itself. This one, I think, has a collapse zone of 400 feet, 95 feet. So yeah, that's
Okay, thank you.
that's kind of the reasons why there's a distance. But setbacks are one of those like normal land development regulations. This one has a 1,000-foot setback, but it is explicitly waivable, usually justified on the collapse zone of the tower.
Thank you.
I've got one other question also. I heard during the comments that this tower does not have a light on the top. Okay, and then some of the concerns about the local air traffic there being that it is helicopter, not fixed wing. Why is it not being required to have a light?
That's the FAA.
But we can put it in our conditions. Is that correct?
I'm going to say yes, but I don't know if that will, if there is a preemption on the FAA on lighting towers that they say don't need to be lit. That may kick in some other kind of analyses in terms of who knows.
So we
with the
could put
federal
it,
level.
we could put the condition in reference if it was, as long as it didn't interfere with the FAA requirements.
Yes, I believe so. Let me check to see if we've got that authority.
Mr. Costa, I'll let you go ahead and ask your question.
While he's looking that up, my only comment on the light would be that if I was the neighbor, I prefer not to have a light blinking in my backyard 24/7, as opposed to that. And again, I have to default back to the FAA on this one. I think it was the distance to the Massey Ranch is the closest, and we're under 200 foot in height. If they're landing aircraft in an uncontrolled field, that's a whole different situation. So, but again, it's a 50-50. You put the light, and all of a sudden now you got a light that's going on all night. So.
I started to say, but you're not flying helicopters around.
Not that we know of.
Yes, sir. Come on.
To reiterate what Mr. Casa said, most people insist that we don't have a light. And
What if they insisted you did? Would you put it on there?
You can voluntarily, you can do it, but you'll find a lot of ordinances throughout the country. They oddly enough have a top height of towers is 199, so they don't have to have the light. Usually the biggest outcry comes from the light on the tower. And again, the FAA They control this. Again, the closest is Massey Ranch. It's about 4.5 miles north. So most folks do not want us to have a light on it.
Well, that was one of the concerns about
Yes, sir.
one of the adjacent property owners. So I don't know. Maybe it's a discussion with them. Would you? I'm not gonna recommend putting it in as a condition, but would you be willing to discuss that with the property owners and
Yeah,
see if you can come to a general consensus on that?
Yes.
Because if he is flying helicopters in and other people are flying in too, this would be a safety concern, I would think. You don't want anybody hitting your tower either.
No, sir. we don't.
And I don't know if that, the FAA mostly looks at landing patterns and that, usually fixed wing aircraft, not someone that's got a helicopter next door. And the last thing we want to do is have a buddy fly his helicopter over, not familiar with that tower, and taking out your tower.
No, we don't want that. It's just,
And so, I mean, there is a circumstance here, obviously, if that's a fact, of him flying helicopters.
yeah. And then the trade-off is folks who live there don't want to see a light.
Well, that's why I said, you know, if you can,
Somewhere in the middle, yeah.
somewhere in the middle there, if you can talk to the adjacent property owners and be willing to do that if you find it necessary.
Yes, sir.
Well, I don't care if it's 75 feet, you know. It's just something that I would think that I don't know why it wouldn't be in there if he is flying helicopters into the adjacent property.
Yes, sir.
Okay. All right, I'll accept the motion. Wake up, guys. I'll accept the
Okay,
motion.
I'll make the motion. I move that case number S-25-006 be approved.
No, final.
Move forward, I'm sorry. That move forward for final action with a recommendation of approval to the county council, subject to staff recommended conditions.
Okay, I've got a motion on the floor to forward the special exception case number S-25-006 to the county council for final action with recommendation of approval, subject to staff recommended conditions. From Ms. Shelley, and a second from Mr. Costa. Any discussion on the motion?
Yes, I would suggest to the applicant strongly that they sit down with the neighboring property owners prior to this going to council for final approval and work out those few kinks that are out there.
And also to council, and also to the adjoining property owners. You really, we're not making the final decision on this. This is a recommendation by this board. Some of the things that you brought up is a concern. Obviously, there's some that we can talk about and some we can't. But those that we can, I would hope that you would try to get with the people that are going to try to put this up and see if there's a general consensus on if you want a light, if you don't want a light. But I would have that ready to go at the county council meeting, because they could always add that. Can they add that to it, Mr. Soria?
Yes.
Okay, they can add that to it at that time. Okay? Okay, all in favor signify by saying aye.
Aye.
Aye. Any opposed? Motion carries unanimously. Okay. All right. That was... Miss Shelley, could I get the next case, please? Please.
Yes, sir.
Oh, this one got continued, canceled.
Yeah.
Okay, we're into
I say,
our
I'm not-
ordinance.
I'm not matching
We
here,
got
yeah.
Mr. Ashley up there
Okay.
already. He's ready to go. The
Case
ordinance.
number, ordinance 25-005, ordinance 2025-13, amending chapter 72 of the Code of Ordinances to amend accessory structure and fence permitting requirement.
Thank you, Miss Shelley. Mr. Ashley, good morning, sir.
Good morning. I made it. As noted, this is a proposed amendment to the zoning ordinance to allow for modifications to some standards relating to accessory structures and to fence permitting. Just a little background for you. The County Council directed staff to evaluate ways to reduce time and cost to the public during permit review process by reducing and eliminating various land development regulations. At the council workshop on July 23rd, 2024, the Volusia Growth Management Department responded with various suggestions and recommendations for the council to consider. After much discussion, they were forwarded to another meeting, which was held on October 1st, 2024, where council gave the concession for staff to move forward on multiple code amendment proposals. Two of those items are the subject of today's ordinance, which are to amend Section 72-277 accessory structures, an exception to the minimum dimensional requirements, accessory dwelling units, and Section 72-282 fences, walls, and hedges of the zoning ordinance of Volusia County. The goal is to eliminate the requirement for a building permit for accessory sheds under 400 square feet and eliminate the requirement for a residential fence permit, except for those functioning as a pool barricade. Currently, all sheds, regardless of their size, require a building permit to verify compliance with minimum structure building setbacks, maximum building height, and maximum lot coverage, in addition to the provisions of the Florida Building Code. And in the residential classification, a fence permit is required to verify compliance with specific height and location requirements. On the first half of the ordinance, dealing with accessory structures or sheds, the ordinance currently allows for a lesser setback for rear and side yards for sheds that are up to 500 square feet. This ordinance is proposed to allow by right sheds 400 square feet in size on single-family residential use properties to be built or constructed without need of a building permit. However, the sheds must still adhere to applicable county accessory structure requirements, well, that would be the yard requirements, Article 3, Division 7 of Flood Hazard Management Requirements of the Land Development Code, as well as compliance with wetland buffer, and gopher tortoise regulations of the Land Development Code in Chapter 50 of the County Code of Ordinances. And regarding the fences, this is the second part of the ordinance. As I noted, the fences are used as a barrier for property. Chapter 72 currently does not include fences as a definition of structure, and it is not referenced in the Florida Building Code as a structure as well. It's only used for a barrier for a swimming pool. We require the permit, obviously, to make sure there's compliance with the location. Fences have varying height based on what yard they're located in. What is being proposed is we're recommending eliminating the permit as directed by council, and that would be for chain link wood or vinyl fences. We would not address the wood, concrete walls or masonry walls. That's a structural element. We're only talking about fences. And even though there would be no specific review, no permit for the items I've referenced, the way we've structured in a direction, the property owner would still be required to comply with the applicable setback, yard requirements for a shed, location for a fence, and height. However, it would be up to the individual property owner to check with the county on the requirements, and if they fail to adhere to the requirements upon receiving a valid complaint, code enforcement would be the initiated to seek compliance. And that's what the goal from council. No permit, but for us to verify it, it will take a compliance situation. And I would kind of go over quickly the ordinance, some of the changes, starting with page 4, just provide a distinction which we don't already have in the code. We are proposing a definition for wall, and that is for the purpose of section 72-282, which a masonry fence which is constructed on a footer serving as a means of protection or confinement. And again, just help distinguish between what a wall and a fence is. We do define what a fence is, but not a wall. The next section deals with our accessory structure. It starts on top of page 3. This is the specific language that we're putting in the ordinance, that accessory sheds under 400 square feet in size located on single-family residential use properties are subject to the standards of this section. and the Article 3, Division 7, flood hazard management, but may be constructed with a shed building permit. Such sheds may not be constructed within any wetland or wetland buffer or within 25 feet of gopher tortoise burrows. And because of this new section, we had to renumber or reletter accessory dwelling units. So there's some formatting changes that are going to be part of this code as well. Next, with the fences, further down on page 3 of the report, we've kind of created a breakdown to make sure we distinguish between residential classifications and non-residential, a little more defined that way. And so what we've referenced here, fences and walls in a residential zoning classification are permitted in any yard, provided they comply with the code, sections as enumerated previously. However, we're allowing for chain link wood or vinyl fences on single-family residential use properties are subject to the standards, but may be constructed or without a fence permit. And that's a distinction, as I mentioned earlier. Fences are not referenced in the Florida Building Code, so there is no building permit. There is a county fence permit. It's more regulated through the zoning office. It's only for the individual lots. As I noted, all residential fences and wall would be like on exterior or perimeter of our subdivision per se. That would still go through the permitting process. As noted, because of this modification to the code, we've had to do some renumbering, relettering for the further sections in the code. And that is essentially the one last change. If we go to page 9, we did have to address the permitting requirements under the administration section in 72-341. For clarification, the language basically said you couldn't put up a fence without a permit. We've made that more specific to non-residential classification uses cannot erect a fence in those areas without a permit. And that is the ordinance. I'd be happy to address any comments or questions you have.
Mr. Costa.
Yep. Morning.
Good morning.
Page 3 of 8 on the ordinance itself, first line. Why 400 feet? As opposed to, say, 500 feet?
That's the number that came out of the discussion with county council at their workshops.
At their workshop?
Yes, sir.
The reason I'm bringing that up is, so a standard two-car garage is 480 square feet, and which would be a pretty good-sized accessory shed. I'm just trying to avoid that extra 80 feet coming in for a variance to go for 80 foot. If we could, my suggestion would be that we change that to either 500 or make that 480 to accommodate that. And then secondly, on that same line, located on single-family residential use properties, as opposed to why the wording, using the wording of non-commercial property as opposed to using the single-family residential to more encompass the, I don't know, it just seems a little restrictive there on the single-family. And then you go back on the other pages and you're talking about non-residential properties. Is the distinction there, I'm kind of lost a little bit.
Well, the specific for that was that's where the issues came up, were brought to council. Not a lot of this initiated issues were about a year ago where we were substantially behind with permitting. We had a big impact to the residential permitting phase. And we were behind. And of course, now and that was part of our, what we call a single phase permitting process. It had to get through building, zoning, environmental, individually, but if somebody was behind, it would stack up. We do now have a two-step process, which you have a clearance process of basically zoning, environmental, and any other non-building group. That has to pass, then it goes to the building department. And that's also tied in with a permitting time shot clock, where there's a certain time permits have to be reviewed and get out. So in that spirit, the council was looking at what are ways to curb the timeline. Our biggest issue is residential permitting. What are the issues that are some of the key things? Accessory structures and fences are some of the bigger, other than new homes. This is something that existing home sites deal with a lot. And how do we get through the process or permitting process faster, cheaper? And these were some issues we thought, well, maybe we can eliminate permitting for those type of issues. And where the specific 400 came from, I can't tell you. That was a council
Okay.
between staff at those two public hearings.
Well, I would make that suggestion, and on that line one would read accessory structures under 480.
Okay.
And I'm not sure why, but I also like I would strike the single-family residential use to read non-commercial property uses to basically more encompass and capture everything else. Personally, I'd like to strike Article 3, Division 7 flood hazard, but I know you're going to tell me that can't be done. That was just a comment.
Okay. We'll move on.
That's it.
That's it. Okay.
Oh, I'm sorry. I lied. I misled you. That same goes for line 15 on that same page. Is strike single-family residential use and change that to non-commercial properties.
Okay. One of the specific things, the distinction there is, and maybe this helps you or doesn't help, under section 72-277, specific zoning classifications are listed, and they are ones that allow for single-family residential use. Multifamily zonings and most of the mobile home park-type zonings, they are not included in the accessory structure standards. Under the fence section, it's kind of a carte blanche. You're either residential or you're non-residential. So the distinction whereas this is going to be single-family residential is these fence standards would be applicable where you get the exemption versus a mobile home park, that type of thing, or multifamily, which also would fall under the residential category.
Mr. Ashley, I'm going to give you a hypothetical. Oh, Ms. Craig, you had a question? I didn't see it.
Further to Mr. Costa's discussion about the size of it, to me, an accessory shed is different from a garage. I think of a shed as being a storage shed that is built and plunked down in the middle of a open area, and a garage is something that's sturdier and it's built for a purpose, and I can envision a need for permitting on something of that sort. Just a comment.
Well, the word shed was specific to the council discussion, so.
Ms. Shelley?
Yeah, I have a question. On page 2 at the bottom, it says reducing costs to citizens and allowing a more affordable housing option.
Yeah, that's a mistake. I had a corrected staff report that should have been provided to all y'all already.
Okay, maybe, okay. I was like, okay, looking at that. Okay. Because I was like, is that making the 400 square the sheds, are they ADUs without any guidelines? I don't know.
I apologize for that.
Okay, thank you for answering that. And then, I understand the request by council, but it does seem interesting to me that you still have to, so if they don't ask or think they need a permit now for a fence or a shed, they certainly aren't going to think they have any. It says they still have the same applicable, the requirements are still in effect, but they just, except for you don't need a permit. So again, it seems to be that back way. Somebody will have to complain again before. Okay, I just find that interesting. Okay.
Okay, get back to my original question. If I've got a piece of agricultural property that's not agriculture exempt, but yet I don't have a resident on it, get back to Mr. Costa's point of making it commercial rather than residential for what? Non-commercial? Yeah, for non-commercial use. Wouldn't that residential clause in there have an effect on an agricultural piece that I'm allowed to put an accessory structure because it is agriculture? Would that be covered under this ordinance?
Well, it allows for residential use. The agricultural zoning is one of our residential single-family use classifications.
Even if I don't have a resident there, I can still put that 400
Well,
square
that's
foot
where
or
you get
480.
to the agricultural use aspect. Is this a non-residential farm building on a farm?
Mr. Chair, I just kind of want to, I guess if you go to page 4 of 8, page 6 of 10, yeah. So the fence section already accounts for agricultural use classifications under former section 4, 5, now section 4. Scroll down a little bit. So 4 of 8. So it says, this section shall not be applied to any agricultural, conservation, or public use classifications. Doesn't require your bona fide ag determination. So we've already accounted for fences to fence off these particular uses. And I think fences are now one of the accessory uses you can have without a primary structure, fences and docks.
Yeah.
Okay.
And
What is your view on the non-commercial
Well,
instead of residential?
I think the concern is what Scott stated, is you have, the residential versus the types of residential developments that you would still require a fence permit for your kind of multifamily type objects. I'm trying to think of a classification that isn't residential, but it also not commercial. Usually you're dealing with your kind of like
When you mention
institutional
multifamily,
type
if you had an
uses.
ADU on the property, that's a multifamily. Multiple family.
No, we don't look at it that way. Multifamily is going to be a building have multiple units in it.
Right.
Or like apartments or condo.
Wouldn't that
but
be
the-
commercial though?
In the commercial?
Wouldn't that be commercial?
Well,
I mean,
not under the-
in your definition of commercial, if you had apartments,
It's a residential use. So certainly from the building code perspective, if you want to talk about commercial, they treat it because you're dealing with a single entity versus multiple owners trying to build one large structure. But from our perspective in the zoning ordinance, that is a residential classification and use, different from commercial.
but they would be able to
And
put a fence up without.
Not in
permit.
multifamily.
Hmm?
Not in a multifamily zoning classification. As it's written, we're restricting this to single family.
Okay, got it. Okay.
And to Paula's point too, section 72-341, which is on page 8 of the package, or excuse me, page 7, it's already in the code there online, starts 15, 16, 17. It's already been in the code that agricultural zonings aren't required to get a fence permit. And that's tied into state law as well.
Right.
They're exempted.
I'm talking about the accessory structure. though.
I know, he was speaking to the other issue, but on the sheds, if agricultural zoning, we still have the provision for allowing more than one principal structure, as long as only one of them's a home. So certainly, if it's a vacant agricultural property, you want to put a storage building of some sort that's agriculturally related, then that's part of that exemption procedure we can have on the non-residential farm building on a farm.
Got it. Okay. Does that satisfy you, Mr. Costa?
Yes and no. I just keep, and I can't pinpoint it, but I'm feeling we're leaving, somebody's getting left out here with that wording, and I'm not sure who it is just yet. Does that make sense? I can't quite put my finger on it, but someone is being left out unintentionally, obviously, and I'm trying to make sure that that's protected. I get the rural part and the agricultural issue. I understand all that. It's just something about the wording single-family residential use. It's I don't know. It's just
Maybe
it's like a burr in my
maybe
shoe.
duplexes are kind of this odd thing where it's not technically multifamily, but it's also not single family.
Yep.
And they put up fences in the same manner as single family residential.
Or a townhome for that matter as well. You've got those are attached townhomes, but they're individual single family units, right?
Those situations, those fences are typically covered on common property. But yeah, it's for those ones, it's I think we treat the townhomes in the same manner as multifamily.
Right. Okay.
It's the duplex ones that are just kind of odd, because you can have duplex development in the middle of, a row of single-family development.
And if you want, you'd like to do that, that might be something to add, is the duplex, because we pretty much only allow duplexes in one zoning classification, the R6, and that R6 also permits single-family residential. So if that, to your suggestion, maybe located on single-family and duplex residential use.
Which you said was what zoning? R6?
R6. It allows both single-family and duplex, two-family.
And you're prohibiting that on the next page, though, R1 through R9 for the fencing, on page 8, line 18, or line 19, rather, on page 4 of 8. I see you're prohibiting the fences through R1 through R9, so R6 is in that grouping?
Those apply to barbed wire and electric fences.
Barbed wire and electric only?
Yes.
Okay.
Yeah, that's what that is.
And that's
All
not, that's not being changed, other than
All
that.
right. Yeah, I like that suggestion regarding the duplexes.
I'd like to get a view on the other members. Ms. Craig's weighed in on the square footage. I'd like to get some kind of a consensus here. I mean, me personally, I don't have an issue with the 480, even 500.
Well, here it comes down to this, I guess, or this is a question. So that there's I'm looking through here, and unless I'm missing it, do you have a definition for the word for accessory shed? What is an accessory shed? Does it have to have four walls, or can it just be an accessory carport, if you will? Is that considered a shed?
Well, we don't have a definition in the ordinance. We do defer to Merriam-Webster's 11th edition if we need one. And they have a definition of shed is a slight structure built for shelter or storage, especially a single-story building with one or more sides enclosed.
One or more sides enclosed. So potentially a two-car carport with the back wall would be a shed. Therein lies my 480 square feet. Yeah, those are drop and go kind of items.
So
That's where I'm at with that one.
I'm with you.
Yeah.
I'm with you. I just didn't know how anyone else felt. Mr. Sixman?
No, I think the 480. I mean, it's so close because you're right, because most of them are an average of 480. Yeah, I definitely say we need 480 or 500, but 480 is perfect.
Yeah.
480 to 500. Ms. Shelley? Where do you stand? I don't want to single out Ms. Craig, but I don't want to overlook her concern. I mean, it can be. Okay.
Staff always does is put in their comments.
Okay.
That were brought up regarding
Yep.
the side
Okay.
concerns.
Well, I'd like to send it with a general consensus, or just not one member's view. Okay, the other thing too, this addresses my chicken coops, don't it? Remember that 10 by 10 chicken coop that had to have a permit in our zoning? This addresses that, don't it? I thought that was the most ridiculous thing I ever heard. Okay. Well, I'm all for this ordinance, I'll be honest with you. I support it 100%. I guess, Mr. Paulo, you've already spoken. Ms. Shelley's spoken. Okay. So I'll entertain a motion. Oh, do we have any public participation for this?
No, sir.
I don't see, I see the attorney here. But no. So we're going to close the floor for public participation and open up for commission discussion and a motion.
Would you like to make a motion?
Go ahead.
Can you turn on your mic?
Having trouble with that today. The PLDRC that we find the ordinance 2025-13 consistent with the comp plan and forward it to the county council for final action with a recommendation of approval.
With member comments?
Subject to comments, yes.
Subject to comments.
All right, second.
Got a motion on the floor from Ms. Shelley to, well, where am I at? Okay. Right here. Okay. Did we find the ordinance 2025-13 consistent with a comprehensive plan and forward it to the county council for final action with a recommendation of approval, subject to the commission comments? And a second from Mr. Sixma. Any discussion on the motion? All those in favor signify by saying aye.
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 Any opposed?
My mic wasn't on.
Okay, motion carries unanimously. Okay.
Thank you very much.
Thank you.
Thank you, Mr. Ashley. Now my friends with chickens don't have to worry about
Nope.
where they're gonna put them. Okay. All right, that's the end of our business for the day. And Ms. Smith, do we have any other public items?
No, sir.
Staff items?
Just very quickly, you all are invited to a public hearing that we'll be holding at the Osteen Elementary School. It's specific to the Osteen local plan. We're going to have a bunch of fun interactive activities and give you the history on the plan and show some case studies. And it is April 9th from 5 to 7 p.m. We hope you'll join us.
Fun activities like piñatas and stuff, or
We're going to let you color, draw.
Where's this is gonna be held?
Osteen
April
Elementary.
9th, 5 to 7 o'clock at the Osteen Elementary, 500 Doyle Road.
She sent an email out.
Got it.
And we've already noticed it, so all the members can come with no problems.
Okay. Staff comments?
Yes, sir. I do have one.
No, you're not a staff.
Oh, I'm sorry.
No, sir.
What, are they
Not collecting a
paying you?
check yet. Yeah, you're right.
Okay. No more commission comments.
Yes,
There you
sir.
go,
I have
Mr.
one.
Compton.
Can we, since we're all here, the ones that are here, can we check our request to speak button? Because I noticed Donna's was popping up as somebody else, but then it got changed.
Yeah.
I think we had a different name.
Yeah. You're Donna now. You were
Miss Summers, she
I fixed it as
Oh,
soon
did
as I
you?
saw
In
it.
midstream, and so all of a sudden I saw her name pop out. I go, hey, it's corrected, self-corrected.
She
Okay.
corrected that when she saw it.
Beautiful. Thank you.
That's already been done.
Thank you.
However, if you'd like to move your seats, now would be the time to tell me so that I can fix it again.
Yeah.
Okay. Ms. Shelley.
Yes, I just, Mr. Source, would you just say, you said it so eloquently before, but about the EMF, just cite what you said.
Yeah, so this has been a thing since the 90s when cell towers started to proliferate. So there's the Telecommunications Act, and the federal government has doubled down more and more on preemptions on local governments. So it essentially says that you cannot base your land use decisions on the environmental effects of radio frequency emissions. So that covers things like, when 5G was starting to proliferate, you had a lot of people start to get concerned, alleging all kind of sorts of things. So, but that kind of prohibition on consideration of environmental effects. So environmental effects is a very broad statement. It includes, allegations that it causes health effects, it causes cancer, that it interferes with animal sonar or something like that, or the way that things move or animals move, so that has been a preemption since the Telecommunications Act of 1996.
Thank you.
There are some other state provisions and preemptions, including you can't, discriminate against a particular service provider. It's like, say, for example, you have a grudge against AT&T, and AT&T wants to put up a cell tower. It can't do that. And some, as the case law has evolved, the way that towers are looked at is kind of very specific. So, allegations on diminution of property values need to be established by an appraiser or someone versed in real estate. If they are opposing a tower based on aesthetic grounds, you know, a plain statement saying it's ugly, it won't suffice. You have to show evidence, and that type of evidence is usually in the form of simulations. You know, you kind of mock up what the tower would look like in relationship to your house, or you can do a balloon test where you shoot a balloon to the height of the tower, and it's like, okay, physically, everyone can see where that top of that balloon is. And I've seen tower cases where a tower is denied because, you know, it looks like the tower is growing straight out of a house. And that is kind of a good example of you should deny this tower because of, one, aesthetic reasons, and two, someone actually provided evidence that it would, you know, radically, you know, interfere with the property values of a particular property. So.
Okay. I'd like to bring up something, as I know we all received our packets this month. There's been some discussion of our Volusia County Doge that do we want to cut costs. And so I've been kicking this around a little bit because there has been some they may approve it, they may not also, of providing laptops instead of print and mail outs. One of the things that I saw when I got my packet was that when I received my packet, it cost $10.50 for them to send it out. And if they don't send it out, it takes time for staff to deliver it. So you usually have a staff member, you're taking away from the staff for a day to deliver packets. So I don't know how you guys feel, but if you want your packets to give some kind of compromise, because a lot of the cases that we hear are on this side of the county, and I know it's tough for the people on the other side, is one of two things. You can either look at it on your online, and I'm not saying they're going to go for this, but it's a compromise from us, so they may or may not do so, would be to either come over and pick up our packet or look at it online, and then if you're in the area, pick it up, and they would have it available for you when you come in that morning if you didn't want to come over and get it. Or if you'd rather have, and I'm not saying we're going to get that either, a laptop, but we all have our own laptops, and I think it was a general consensus. We like to have the packets in order to make notes on and visually look at something without having to scroll through it while we're looking at each individual case, because I know we all do it. We make notes on talking points. We all like it. If not, at the least, I would like to have a packet here on my desk when I come in for a meeting. What do you guys think about that?
Totally agree with that.
County office that's on the other side of the county, to use my own instance as an example.
Can I have you on the mic, please?
I'm sorry. If there's a shuttle or, you know, a delivery between this office and the other offices where things could be dropped off and more easily picked up than driving all the way over here, that would certainly help as well.
Do you guys have an office on the other side of the county for planning?
No, we don't. I think our preference would be either your recommendation of we have the packets available here, or for those that don't want to come to this side of town, that we go ahead and mail them. That would be a little easier on us.
Okay. Well, I don't know if that's going to fly as far as, I mean, my understanding is we're not going to get them mailed to us. They're more or less either we're getting laptops or no packets at all.
Well, it's not laptops. We are looking at getting iPads.
iPads.
Just so you're aware of it, though, if you do get an iPad, and they're still working through
Going
that.
for a laptop.
If you do get an iPad, they will not have Wi-Fi access, so you will still have to download your information from the website to that iPad before you go out on your site visits.
I think it won't have cellular access.
Okay, so you do. Yeah, I was going to say you have to have
And
Wi-Fi
pop,
access.
yeah.
You can download it. So all right, got it. And that'd be a county-owned piece of equipment, county-owned, maintained?
If they agree to it. They have not agreed to it yet.
If,
We are
okay,
waiting
if
to-
and when they agree.
I will tell you, we did send the chair's letter on, and the response we got back was, no, we're going digital. I think they've come off of that a little bit now and are willing to explore iPads. We're waiting for the response.
And I'm willing, what I'm saying, I know how much we like our packets, and I was coming up with a compromise. Okay, we're going to cut your costs. Meet us halfway. Let us have our packets, but we'll pick them up either the morning that we come here, or we'll make a time to come over and pick them up from the office here. Like I said, we do have cases on this side of the county. If you're coming over to look at that case, put it on your number one list, go ahead and pick up your packet and move on. So I don't have a problem with that, but I think the incentive of the mailing costs and providing this staff member to go out and deliver them, either or, would be a logical compromise. What do you guys think? I mean, I'm not going to.
I mean, I'm willing to come in. I'm willing to drive in here and pick mine up, because when I go visit sites, I like to visually have something I can sit there, write and make notes on. So I definitely like the paper.
So you guys okay with making that
I'm fine with it.
recommendation? Are y'all okay with making that recommendation?
Yeah.
Give that to me one more time.
That compromise?
Give me that compromise once more.
Compromise would be that we would still get our packets, but instead of them mailing it out or sending the staff member to deliver them, because that is a cost. And that, I think, from what I'm hearing, they're trying to cut costs and everything from paper clips to to postage stamps.
Fine, right.
And so my point is, if we give them a compromise, that we would pick the packets up either the morning that we arrive here, or if we're in this area looking at a site, that we pick them up then, or whenever they're ready. You can pick them up. You can pick them up beforehand, or
Get them day of.
or day of. Yes.
We always email you the Wednesday before the meeting to let you know that it's online and published, and that's the same day we have been mailing out the packets. So in this case, you would get an email on Wednesday saying it's available. And we
1
will,
week in a.
I'm sorry?
You do it 8 days, not the Wednesday before. Our meeting's on Thursday.
Yeah.
The week before, the Wednesday before we
Yeah,
publish.
you said the Wednesday before.
Not the Wednesday before the meeting, the week before, the Wednesday of the week before the meeting, we notify you all that it's ready. So I think what you're proposing is we'll still print those packages on that Wednesday. We'll have them available in our office, either for you to pick up throughout the week, or we'll have them here available for you at the Thursday meeting.
As opposed to mailing them,
Or not getting them at all.
Yeah.
That's my concern. I'm afraid that it's going to end up that we're not getting them at all. But
They go tablet.
because I've even heard
Yeah.
that, yeah. But really, when you're looking at a case, I mean, they put it up on the prompter here. Unless you got something here that we can go back. I go back all the time.
Same here, yeah.
Go back and forth, and I make little notes all the time. And to sit here to be with a tablet, even with a tablet, of trying to make the notes and everything. I mean, I might as well do it on this, So I just believe it takes away from the presentation when you have to do that. So.
I'm in agreement with your compromise.
Okay, you're good with that? Everybody good? All right.
So just for clarification, is that in lieu of getting a potential iPad, you'd rather have the hard copy?
I'd rather have the hard copy, yeah.
Thank you.
Yep. We good with that? All right. And then any changes, you can send us something by email. And I know we get a stipend, but I will say this again, it does not cover our fuel, much less printing costs. Okay? Not that much. You realize that stipend hasn't been changed? I know in 20 years. I know for a fact it hasn't been. So, because I've been here almost that long.
That's a 1990 something resolution that set the amount and that hasn't been changed.
Why don't we get a little bit more? You realize what it was worth back then to what it's worth today? Aren't we worth that? Put that in their ear, Mr. Soria. You know. Now we got costs. We got to come over and pick up our packet. See. All right. Okay. Any press and citizen comments? This meeting's adjourned. No.